Should I mark it on Robert?
You just
We're
hold
on the
to
record,
it.
Robert. Thank you.
All right, thank you. All right, let's get called to order here. I'm trying to see. Pretty much everybody's sort of in place. So this is a notice of the December 6, 2018 meeting of the Board of Architects and Engineers Examiner. This notice was posted on the Board of Architects and Engineering Examiners website on November 28, 2018. And I will act like I know what I'm doing, and we'll go to roll call, please.
Susan Ballard.
Here.
Robert Campbell.
Here.
Ricky Bersai.
Here.
Grant Minshew. Blair Parker.
Here.
Brian Tibbs. Rick Thompson.
Here.
Frank Wagster.
Here.
Kathy Ware.
Here.
Alton Heathcote.
Happy holidays.
Stephen King.
Here.
You have a quorum.
Mr. Heathcote, I will want to point out that I'm not sure that acknowledged your presence
Here.
or absence, but we will take it as your presence being here. I'm in that mood today. Sorry.
It's okay. So beware.
Yeah. My wife told me what she bought yesterday for Christmas, so I'm hating the holiday already. All right. Acknowledged guests. I see one, Casey Anderson from the ACEC and TSPE, and it's an almost guest. Sarah's back there, but she's part of Legal's group, so I think everybody else is home folk. Okay. Any announcements? We got one more guest. Don Baltimore has walked in with landscape architect. I mean, with interior designer. Excuse me. And any announcements? I know that we will talk later on about what we have going on after the meeting, because we do have another meeting with QBS that starts at 2:00. So my goal is to kind of get through this to make sure that we've got plenty of time in between for lunch for everybody that's staying over. Any other announcements, Roxana, that we have?
No, I think you've done it all.
Okay, very good. Give you a chance, any changes to the agenda that we may have? Nothing? No. Do what? Oh, yeah. Ashley Kate from the AIA is here as well. Instead of having you do formal introductions, I'm just going to go ahead and do it, and that way it moves it on. You'll get a chance to talk here in a little bit. No changes to the agenda. We will consider it set then. Our minutes, and they're on page 3 of your iPad. And again, I want to thank staff for putting the page numbers on the iPad out there. That's extremely helpful in trying to go find these things. It really does make a big difference. It keeps us from flipping through here, especially fat-fingered ones like me. So thank you for that. So if you look at page 3 of your iPads, the minutes from the October 2018 board meeting, and I'll give you just a second to look back over those. I know you've reviewed them, but just in case you want to refresh yourself on those. And I will at some point need a motion to approve or discuss.
I move to approve the minutes.
A second.
Any discussion? Oh, yes, ma'am. Whoa. What? Is that for the minutes?
Yes. Ashley Cates was not present, and I believe she is tagged as I think there might have been a name shift between Ashley and Casey on somewhere on the minutes that Ashley noticed.
It says Ashley Cates reported for TSPE.
Okay.
We will fix. Thank you for catching.
Right. Yeah, thank you. Didn't see that. Appreciate that. Okay. Thank you very much. All right. Anything else? So we've got a motion and a second. Discussion. All in favor say aye.
Aye.
As opposed, and the aye will be with the change noted, please. Okay. Now we go to professional society reports, and whoever wants to go first. Yeah, go ahead, Casey, that'd be great. I can't see everybody else out there.
I think they're getting organized. Casey Anderson with the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. I will be very brief. We are hosting some risk management seminars yesterday, along with the local chapters of AIA. Yesterday they were in Knoxville. Today they are in Nashville. Tomorrow they will be in Memphis. A couple hundred people attending those. We talked for a while yesterday in the engineering committee about decoupling. We do have a committee that is going to get together very soon. And TSP will lead that charge, but the committee will be representative of a lot of different of the associations that are the engineering technical associations, as well as the trade association and the professional association. And we are spending a significant amount of time gearing up for the transition both at the legislature and in the executive branch, and working hard to make sure that people understand what professional engineers do and all of the pieces and parts that go with that. Unless you have any questions, that's all I'll share.
Anybody? Casey, thank you, and thank you for getting together on the decoupling. I think it is time that we kind of get an industry solution to that because it looks like it's knocking in our door more and more and could create more issues for us. So thank you for that. All right. Who wants to go next? Ashley?
Good morning, Ashley Cates, Executive Vice President of AIA Tennessee. So our Day on the Hill, we're planning it. We're also working on the transition and the administration. So our Day on the Hill will be on March 5th. We're going to have a joint reception, I think, with the engineers and the contractors. And then we're going to also do a strategic plan this year for the next 3 years. We're going to be in the process of that. So if there are things that are on your agenda, specifically with NCARB or anything like that, I'd love to talk with you all about them and see how we can incorporate that into the strategic plan so our board is aware of it with the emerging professionals in our emerging professional group. They will be able to work on those projects. Other than that, our conference is set for July 17th through the 19th in Knoxville. We're excited about it. And then also, if you all need any assistance, I believe NCARB is also coming here this year in Nashville for the conference. So be happy to help out and assist and promote whatever we need to do with that. So if anyone have any questions.
Any questions from anybody? So it sounds like you all have got a busy year coming up.
Do.
That's
Yes.
good. Very good. Anything? All right. Thank you very much.
Good morning. I'm Don Baltimore with Tennessee Interior Design Education and Advocacy, or Tennessee IDEA. The state interior designers really don't have a whole lot on their agenda for next year during the legislative session, other than to monitor and be supportive of any issues that the board supports in the legislature, and watch out for any issues that are harmful to any of our professions. Several members of the interior design profession attended the CIDQ annual meeting here, which of course Susan will report on in more detail later. It's well attended. It's well-deserved accolades for that meeting, and we are just willing to work with you and happy to start out the new year again. Thank you.
Questions for Don from anybody? All right, thank you very much. I mentioned a couple other visitors that we have that I noticed in the audience, and again, they're fairly regular. Chris Gwaltney is here with us, as well as Nathan Ridley is here. Do you want to give your report now since you just walked in, or do you have anything to say? Very good. I need my civics lesson this moment.
Oh, it'd be a blue Christmas without you, Mr. Chairman, so we need a little of that. Good morning. I'm Nathan Ridley. I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects. I don't have show and tell today, but I sort of have show and tell. The most important thing for me for the past few days, or since November the 6th, has been these little flashcards I made for myself to learn the 28 new members of the House. I mean, my boys say that I'm the biggest nerd in America, and they're probably probably right. But 28's a lot for me. So 28 of 99, that's a lot of new folks, and most of them can't find the Capitol right now. So we have our civics approach. We're going to be pretty busy to tell them what we do. As you get a chance, and they're scattered all across the state, there's no real pattern, and it wasn't because of a lot of defeats in the election process. A lot of folks just didn't seek re-election. They chose to retire at the end of Governor Haslam's second term, and some with many years of service. And with sadness, I would report that a good friend of mine and a leader of the legislature, Representative Charles Sargent, passed just recently, and his loss will be felt from an institutional memory. And also, he probably knew more about our budget than we do because he was just an expert on state finances, and he will be missed. But yes, I'm sure the others have said the General Assembly, the 111th General Assembly, will return to town on January the 8th. And Governor Haslam's term will expire on the 19th with the inauguration of Governor-elect Bill Lee on the 19th of January, Saturday. It'll probably be snowing. And then the General Assembly will go into recess for a couple of weeks, and they'll get started in full force early in February, about February the 4th. Then the bill filing deadline will be probably the middle of February, and they'll probably run until about the middle of May. And I would expect chaos and bedlam for state government this year, just because you have a lot of new House members, new Senate leadership. Lieutenant Governor McNally's still there, but they'll have a new majority leader, a new caucus leader in the Senate on the Republican side, and also on the Democratic side. But it doesn't matter as much because y'all remember it's still 28-5. Republicans to Democrats in the Senate. The partisan majority is about the same as it was, and the Democrats might have picked up one seat in the House, so 75 to 24, whatever the math is, 24. But yeah, they'll struggle a little bit in their sea legs under them. So the nice side for that, for us, is it's a good chance to educate, because they are just blank sheets. They don't know what y'all do. So it's a wonderful opportunity. Send them a Christmas card. Say, hey, I'd like to meet you in the district for a cup of coffee and tell you a little bit about our profession and the regulatory approach that the state takes to protect the health, safety, and welfare of 6.6 million Tennesseans in the built environment. So that's all I have. Look forward to working with y'all. See you.
Thank you very much. Any questions?
I've got one question. Nathan, do you have a list of the new elected officials?
Well, I do.
Other than that in your pocket?
Yeah, I actually do. I could send to your staff, maybe for distribution, for a buddy of mine. I'll send them to Roxanna. Oh, good catch. Thanks.
you.
I'll be happy to do that.
Yes, Chris.
I'm Chris Gwaltney with ASCE, and I'd just like to first thank Casey for organizing the group to discuss the decoupling issues. We've been kind of waiting for this to happen, and now we're going to go with it. So I'm happy to see that happen. I want to put my Lipscomb hat on for just a second and thank Roxanna and Alton for coming by to our senior design course last week, I think it was, and discuss professional licensure. So the kids enjoyed it. I know they've been talking about it. So thank you.
And thank you for promoting the profession within Lipscomb. That's a great thing to do. Appreciate that. Anything else? All right. Let's go then to our legal case report, and it starts on page 14. And my computer's upside down, so I'm
Good morning. The first item on the legal report today is item number 1, complaint number 2018-069351. This is a professional engineer, and there was no reviewer that looked at this case. This is basically a self-report case. This individual's registration expired July 31st, 2017. This respondent reapplied on August 23rd, 2018, and in his expired license affidavit, he did note that he did practice engineering on his expired license. He also included a letter explaining that the combination of him moving and either not receiving his renewal notice or losing it in the move resulted in him mistakenly believing that his renewal was not due until 2018. Mitigating factors here are it is self-reported. There were no aggravating factors. Legal would recommend authorization for a formal hearing and a civil penalty in the amount of $500 for practicing on an expired license. Legal would also recommend respondent is to take and pass the laws and rules examination.
All right, you've heard it. Questions?
I am curious, and I don't recall how we have dealt with these in the past, but this was 13 months where he continued to work without understanding or knowing that his license had lapsed. But do we have any idea how many sets of plans that he was involved in or had stamped during that time?
I don't have the answer to that question. Okay. He just noted on the affidavit that he did practice engineering during the expired time.
If it helps from just a consistency standpoint, we recently moved to doing $500 pretty consistently, despite the number. I think we had a few that started to get a little steep because it just depended on individual casework and what their roles were. So I think that's pretty consistent with how we've been doing it. But it is nice sometimes to know how many. So
well, my main thing is I just want to be consistent. So that was the reason for the email. So good. Okay.
Any other questions? I do have one, if nobody else has. The formal hearing, and I apologize, my mind doesn't remember all the time. That means that if he doesn't agree to the settlement, then we will authorize a formal, is that correct?
Yes.
Okay. Just want to make sure that that's if he doesn't agree to the settlement. Okay. Again, I forget things from time to time. All right, any questions, discussions? Yes, sir, Steve.
If I'm reading this correctly, the recommendation is for a $1,000 penalty, and Sarah just, am I on the wrong item?
Oh, you're on the right. It's on
number
page
1.
14. It's a $500 penalty, I believe. On page 14 of your iPad, Steve.
Okay. I'm on the wrong one. Thank you.
Correct.
In the minutes. Thank you.
Any questions, more? Frank,
Mr. Chairman, I would like to move that we accept the recommendation of our legal counsel and authorize a civil penalty in the amount of $500 for practicing on an expired license, authorize a formal hearing, and also require that the respondent take and pass the laws and rules exam.
I have a second.
I'll second.
Any more discussion? Seeing none, all in favor say aye.
Aye.
Those opposed? The ayes have it. All right, item number 2, please, and that's on your page 15 on your iPads.
Item number 2 this morning is complaint number 2018072951. This is an unlicensed person with no disciplinary history. Here we had a complaint that was filed alleging the respondent was using the title civil engineer without being licensed to do so. And in support of this allegation, the complainant provided a snip from a Facebook page in which the respondent stated, quote, "My name is respondent and my profession is that of a civil engineer working on natural gas pipelines," close quote. In response, the respondent admitted that he is not licensed by the board, but explained that he did not intend to use the title engineer to any personal or professional gain, but used that word to be descriptive, and it was used during the course of political speech. The respondent further explained that after he consulted with his attorney on this matter, he removed all the question posts from the Facebook page. The mitigating factors here are that the posts have been removed. There were no aggravating factors. So legal would recommend a letter of warning.
Discussion on that?
Do we know if this person is educated as an engineer?
It is my understanding that the respondent does have an engineering degree that he received in a different state.
if this individual designs for a living?
I don't have that information. I can say that this complaint was a title issue complaint, and so I have no evidence indicating he has been providing unlicensed services.
Yes, Kathy, sorry.
When he said he was using the title in political speech, can you elaborate?
Yes, it is my understanding that this person was running for political office and made the statement in that post regarding the relevant jurisdiction's sewer treatment system. I believe he was trying to say that he's qualified to talk about the sewer treatment system.
So it's just your impression that he was trying to gain credibility as having some higher level of knowledge because he was an engineer? I'm just curious. It doesn't really affect my recommendation. I just want to know why he was, because that plays to some of the other issues we talk about all the time. Does he think that he had a higher position of importance and subject matter expertise because he's, by saying, I'm an engineer. You should believe me. I'm an engineer.
Well, I can't answer that question because I haven't personally spoken with the respondent on that issue. He did submit a written response, and that's why I said in here that he explained that he was using that word to be descriptive and using it in the course of political speech.
I think you answered my question. I appreciate it.
All right. Any other comments? I would like, because this is a title act, I think maybe adding the laws and rules on here, which do help to address some of that, and passing that might be a good thing too.
I agree, especially if he has a degree in engineering.
Yeah.
He's not one of our...
He's not
registered.
he's not licensed by this board.
I understand he's not licensed, but you said he does have an engineering degree?
That is my understanding,
Yeah.
that he has an engineering
Then he
degree.
needs to know what if,
I mean, he needs to know what if we're going to discipline him, he needs to know what we see as violation. He needs to do some research under our rules if we're going to discipline him on that, so he understands why it sticks with him a little bit more. Does that make sense?
If it helps, a lot of times when we do a letter, we make sure we include those rules. We could send him the laws and rules exam, but just for consistency's sake, that would be the first time we've ever sent an unlicensed person that I'm aware of the laws and rules examination.
Understand. But and again, I don't want to speak over what Kathy's saying, but I think we've got a broader discussion here where people are using the title engineer to gain an advantage in credibility when they present themselves to the public, and just as they would with the word architect or anything, they use that to gain a higher standing, in front of a board or in a political process, and he needs to understand why that's not appropriate.
Did you want them to add the laws and rules that apply to this, or have him take the laws and rules exam?
I think to have him take and pass the
Now,
law.
he's not our licensee, is what I think
I
we're
understand
saying.
that.
So he may not take it. Okay.
Right, but I mean, we're also sending him a letter of warning, and we possibly, if we had decided to, could have disciplined him with a monetary penalty or some other thing. So we can ask that he do that. Now, he obviously may choose not to do that because he's not, but then we can see what we need to do from there. Yes, Susan. No, it was Kathy. I'm sorry. I'm looking.
Well, he has the possibility of being registered.
Sure he does.
He has the possibility of being registered. And Sarah, I just wanted to ask, so you said that this would be precedent setting because we haven't done this in the past, but in the past, have most of the cases been unlicensed title violations by non-engineering graduates?
It has happened.
Okay.
I mean, many times. I mean, often
Many
that
times.
tends to be the
Right,
way it is.
right,
Yeah, as
yeah.
you all know.
Yeah.
It tends to be folks that have that undergrad degree that are most likely to misuse the title.
Yeah, yeah.
So
Yeah,
that's true.
that's kind of my point, is that this person has the potential to become a registrant, and I'd rather nip this in the bud by getting him to educate himself a little bit on why it's important, if he has an engineering degree, not to go out there and call himself something that he's not. That's my point.
I agree. Steve, sorry. And then, did I get that order right? Yes. Okay.
I think we at least ought to discuss whether a penalty is in order. And I was trying to find it, but as I recall, but I can't put my finger on it, there is something in our guidelines about Title Act violations.
That's following where I was with Stephen as well. Actually, I would suggest that when things like this come up that you're not familiar with, that you could check with the engineers or the architects, whatever the case may be. And we know you're young and you're new and you're learning, but to me, this is a clear violation. They were trying to gain from it, whether he says he did or did not. And if he's eligible to be an engineer, then he is, subjected to, the things that we hold to be important here. So,
if I may, I actually assisted her on this case. This is consistent with what we've done, and she did confer with me about this. I just want to also point out to make sure you know the laws and rules exam is quite comprehensive. So the only thing I would warn the board, or at least point out about this exam, is it may contain things this individual really truly doesn't have knowledge of because they haven't been asked to sit for the examinations that this would be based on. So just as a consideration, the exam isn't just our laws and rules, it even has some technical questions. So it might be difficult or quite stressful on someone to receive it and not know how to tackle that. So maybe there's a middle ground of having him sign the letter of warning and return it, showing that he read through the title acts, maybe as a middle ground, just so we don't send him something that probably may be completely outside his, not only what he does, but his education background as well. So,
Sarah, would it be more painful than paying a check?
I just don't know if it's feasible. He could feasibly pay, but whether he could feasibly take the test, I don't know.
Okay. Maybe maybe he has to take it and not pass it. I think we want to educate. The point is, I think the board feels very strongly that because he has a degree and it sounds like he was trying to present himself as something that he's not, that we just want him to be educated about the impact, the impact to the public's health, safety, and welfare, as opposed to just giving him a slap on the wrist. We just want him to be more aware and to acknowledge the seriousness of what he did, not just social media makes everything just so easy to overlook, and we don't want him to do that. That's the whole point.
I would just like to point out as well, and I put this in the legal report, I do think the respondent, now I can't speak for the respondent, I would imagine he does understand the severity of the issue, as he did hire an attorney after the complaint was filed, and did let us know that after he consulted with an attorney, he removed all of those questioned posts from the Facebook page, and I don't know how much he paid his attorney, but I'm sure he would have paid him something for the legal advice that attorney provided.
Yeah, and I think that's a good. Alton, I'm sorry, I didn't see you.
Go ahead.
No. You were up way before I was.
Do we have any methodology for monitoring that in the future? I mean, if he's done it once, and it was to his benefit to do it because it potentially secured him additional work or gave him credibility, we don't have any methodology for putting that on a watch list and going back and monitoring it a year from now, put it on a calendar, an Outlook calendar.
So no, our database, our legal division does not have its own database. We use the database that your program has for your licensees. There's an enforcement module in there. That enforcement module does not have what I came up to learn as called ticklers, which it has like a time reference that links to your Outlook. So everything that we do on a schedule is by our own personal Outlook calendars. But what we do have is that any person who has been disciplined by a board, that pops up on their that would pop up on a box. So it's I know. And so normally what you would see is you would see that somebody who is a licensee, it would show up on a box that their licensee. It says, oh, they've previously been disciplined. Every time we touch our license, it does that. That doesn't occur if somebody's not licensed with us. So for instance, this person here, we would have a complaint open against that person. It would have their name on that. But if they became licensed in the future, the database may or may not link them together or whatnot. So unfortunately, it does. I kind of shook my head. No, sorry, Mr. Heathcott. But we don't have a system for doing that. If you ask us to, we will put something on the calendar on these one-on-one issues to monitor and check this. we can absolutely do that, but it's not a standard practice for us.
How difficult or complicated it is if we ask you to do that? How onerous is that?
Well, it would go on the person's calendar that you asked us to put it on. We would put it on the calendar. We don't have a tracking mechanism. It would show up on probably a couple people's calendar within the future. We would reference this matter or whatnot, and when it would come up, we would say, oh, we're going to check this for whatever reason and whatnot. I've never had that question asked before, but there are things that I monitor 6 months from now or whatnot, and I put it on my calendar.
I mean, if this individual has done it before and it aided in his business development, there's a potential that he could do it again, and unless somebody complained or saw it, we'd have no record of it, no knowledge, and I'd really like to see if we could do that.
And when you say monitor, would you want us to go and investigate and do something like that?
I'm just saying, again, put it on an Outlook calendar for sometime in the future, a year from now, whatever, to just go back and check his Facebook page, website, whatever, to make sure he's not he, she, they are not using the moniker.
Yes, we can do that. If you all make the motion to do that, we will do that. And I do have a question. I guess, Ms. Ballard, you asked that we would consult with the engineers and architects on some of these matters or whatnot. Is that standard, and who is the person that we go to for that? Because I know Sarah had a methodology, but I want to make sure that I do ask the board so that I know that we do have those volunteers that we can contact. And I think this board, I've been absolutely impressed by the communication that you all have with our office on these complaints. It's astronomical, and other boards don't do that as well or whatnot. But I want to make sure that we're asking the right people and we're not, air quotes, bothering somebody they haven't been designated to do that.
But let me grab this real quick. I think it's just typically one of the associate members who may not be voting, that's not in that jurisdiction, if it's in the state somewhere, just to maybe ask that question. It's absolutely, what you've done here is correct. I mean, as far as going through the process and getting what we've done, but sometimes just there are certain words and things that we look at and go, wait a minute, that's a little bit bigger deal than they look like on the face. And again, this doesn't look like a big deal on the surface. He took it down, he took care of it, blah, 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 but it could be indicative of something a little bit deeper than that, and I think that's why the follow-up is important. So just and anybody on the one of the associate members, and it's typical. I think that so if it's somebody from East Tennessee, you contact. Well, we don't have it. Whoever, Alton or somebody.
We don't have a West Tennessee.
Yeah, but somebody that would not be familiar with that person. And I know we do it really well on cases where there's technical stuff to review, but sometimes on these type of things that just a quick question. I mean, it takes us 5 minutes to look it up and say, yeah, that's a little bit bigger deal, or no, you're exactly. And I think that helps us moving forward with that. But again, I think the complaints, everything's fine. There are some little pieces and parts that we look at a little different. Ricky, then Rick, so I get to do the double deal here, right?
I was just going to say the same thing, basically. Excuse me. When I've had counsel contact me before to ask a question, and I don't know that we have anyone that's designated specifically for that. So, we're all available. And again, like Mr. Chairman said, if it's an East Tennessee issue, then I probably shouldn't be the one that's being contacted about it, even though I don't know the name. So, we're available. So if you have any questions, please feel free to contact me.
That is very helpful. Thank you. Thank you.
Listening to the good discussion about what to do, and that it's kind of a small matter, and it does have the mitigating factor. The posts have been removed, but it is, we do have a Title Act, and somebody who calls themselves an engineer or an architect, it's like calling themselves an attorney or a doctor to the public. It looks to me like if it's not really appropriate to have them take and pass the laws and rules test because they're not a registrant, and I understand that. That makes sense. Maybe the most effective thing is a $500 fine because we do have a table that talks about unlicensed practice and calling oneself it looks like the respondent called themselves an engineer at least twice, once on Facebook and once in the course of a political speech. So that looks like twice to me, unless I misunderstood.
was the political speech.
That was the speech.
Right, we only have evidence of the one Facebook
Okay.
post. Yeah.
Okay. So out there though, so maybe a $500 fine is a better education than taking the laws and rules test, just for the consideration of the board.
Well, first of all, can we fine a non-registrant? I suppose we can. And I'm also assuming that we have the opportunity, if we needed to take some sort of civil or litigative action against them if we needed to. Okay. In response, I guess, to the other question about resources available, my recommendation would probably be anybody. Roxana may be the lead on that, or Tony or Ashley or whoever. But all of us, I echo Rick's statement earlier that any of us are available for those at any time we're needed. I mean, we knew what we were doing when we agreed to serve on this board, and we want to be a resource however you need us to be.
So I'm looking for a motion. Begging for a motion, actually.
I'll try to make a motion. I make a motion that we impose a $500 fine on the use of the title inappropriately, and that we attempt to get them to take their laws and rules examination. And a letter of warning, and leaving it open for the potential case, so, which is now off my computer, so anyway.
Put a temporary task out in Outlook for 6 months or whatever.
Yeah.
Okay.
You want to do the...
I'm mean.
All right. So go ahead.
I clarify, if they don't do the test, then what would you want us to do? Because that
Goes
would
in
be
a file, and when
Right.
they want to be something, registered, licensed, then it comes back up, so.
Let me maybe help nuance the motion just a little bit. If the motion to be a $500 penalty, a letter of warning, and then sending them the section of the law and rules that they violate, with that highlighted in the letter of warning, that the board had the lengthy discussion about this and considered this, that you violated, and that brings very serious consequences or something. Because I agree, I don't think we can make them pass that after I've heard the discussion. So they could just throw that in the trash can and, at least let them know exactly what. And I know letter of warning addresses some of that, but, maybe, go ahead.
We typically don't do a letter of warning in addition to a civil penalty, and that's because a letter of warning isn't like a technical disciplinary action. And if we try to do authorization for a civil penalty and authorization for a formal hearing, in the event that this particular respondent does not want to accept the settlement offer of $500, we would have a formal hearing, but that would all be an actual disciplinary action versus a letter of warning, which is basically like, you can't do this.
I understand. Okay.
Right. I think I may know what you're all asking. If I could help clarify, I think because there's technical terms when you say a letter of warning. I think what you all intend is for there to be an issuance of a $500 civil penalty, and within the language of that order, we provide them a formal warning on this language not to use it again.
Exactly.
Okay.
I think that's very good. Well, thank you very much. That's exactly what we want. Yeah. And the monitoring at 6 months to look at his Facebook page again. All right, do I have a second on that?
I'll second.
Any more discussion? All those in favor say aye.
Aye.
Opposed? The ayes have it. All right, number 3.
Before we go to number
Hold on a
3, I just want to make sure I'm clear on what the motion was, because I know there was quite a bit of discussion. So you've authorized a civil penalty in the amount of $500 for the unlicensed use of the title, and you additionally want there to be warning language in the consent order that he's not allowed to use that title without being licensed.
Correct. And then if you want, however you want to do that as far as attaching the particular section, or if you want to say the board had lengthy discussion and in reference to this section about how that was not acceptable or something, that would be perfectly great. Yes, thank you very much.
Thank you.
Steve?
Before we leave that, not specifically to the motion, but to the discussion about the board reviewing certain things, my opinion is that it's not, it is okay for us to review things in our grand division as long as we don't have a conflict. Many times, attorneys have called me and we've talked about an issue, and it's been somebody that I know, but I don't really know personally, but I didn't, and we discussed that relationship, and the attorney concluded that I didn't have a conflict, so I reviewed it. I just want to make sure
that's fine.
The board understands that.
Yeah, that's perfect. Okay. It's just in general, the divisions are better, but that's fine. Okay. Represents on number 1, and I think Sarah's got this one if I've got the nomenclature
I brought a surprise case, sorry. So I've got 2. This one we discussed at the last meeting. This was an instance where they had 2 engineers working at a firm, and they ended up breaking off from the firm and starting their own practice, and there was a multitude of allegations, most of them relating to the employment relationship, whether they stole client lists, whether they used their on-the-clock time to garner business. And Robert helped me look at that one, and I think we all shared the same concerns, which is as litigation goes forward, what is the potential that perhaps a violation that does fall within the jurisdiction of this board comes forward. So out of an abundance of caution, we put it in litigation monitoring to see how that played out. 4 days later, they settled it out as a case that didn't have merit. So it seemed pretty quickly that we were on the right track. I think it was still good of this board to be cautious, but at this point, the litigation was resolved, and all the parties have walked their separate ways, and it happened quite swiftly, which indicates to me there was likely nothing for us to look at. So I've recommended closure on these 2 cases.
Right, do we have a motion on that?
Move to close.
Second?
Second.
Any discussion? All in favor say aye.
Aye.
Those opposed? And the ayes have it. Thank you very much. And now you've got the mystery case.
That's a mystery case. This is a supplement. Steve King and I were able to review this case originally, and the facts were an engineer was asked to come in and do a review of an, I'm going to try to use the right word, LVL, is that right? Okay, yes. I'm learning, see? For a wall replacement, the beam and the support columns and the structure that supports it. He issued a letter to the relevant code authority, and everything went forward. The homeowners that had that work done sold the home, and in the process of that sale, a home inspection was conducted. The home inspector indicated that in their review there were some issues with supports under the floor, and they took some pictures of some things, a jack that was swiveling, footing that the home inspector alleged was under the support beam that was in just one of those, I see them with porches, like just the concrete thing instead of how it should be. And so we opened the complaint to look into. Steve reviewed it. Unfortunately, the homeowner did not approve us getting a really clear copy of the new homeowner, not interested in playing with us, wouldn't give us a nice copy of the home inspection report. So we were really working off pretty fuzzy black and white copied pictures. I had sent that report to the respondent to look at, and we had asked him some questions about the scope of his review, and he had responded that he had only reviewed the beam and nothing else. And we had all discussed that doesn't seem to be taking into consideration the health, safety, and welfare, because the beam in and of itself is not the thing that, we need to know what's holding up the beam. And so based on that, we moved forward on a $1,000 civil penalty. After that was issued, that's why we're back. We had an informal conference. On the phone with the respondent, it became very clear to me that his response was is in relation to the issues indicated in the home inspector's report, which after Steve and I were able to meet with the contractor and with the engineer, it appears those support systems that failed were not related to the LVL at all. Additionally, he supported his statement. He walked through his process of reviewing the full supports. He indicated in his stamped review that he had done that, that he had reviewed the supports all the way through to the ground, and that it seemed to be, in my impression, and Steve, I can let speak onto it, that there was a misunderstanding between my emailed questions and what I was asking him about. I think he was so caught up with the allegation that this whole house's foundation was failing and that that's well beyond what he was hired to do, that he was trying to argue that part of it and did not understand we were looking at a very much more narrow review of those support columns. But Steve was able to speak with him and test him with his knowledge a little of that home and had him draw out blueprints and show us how it worked. So Steve, is there anything you want to add on this case?
You may remember this from, I think this was last time, and I, along with you, were concerned because we did have a statement in an email from the engineer that said that he didn't analyze the total support system. Well, like Sarah described, I think this individual got caught up in responding to allegations in the residential housing inspection that had photographs of many different, or very black and white fuzzy photographs of some kind of support in the crawl space that he was trying to defend himself to by saying he wasn't hired to analyze that. Well, we weren't asking him to analyze that. We wanted to know that the LVL beam that he checked had appropriate columns and appropriate foundation underneath the ends of the beam. And I was able to conclude yesterday through talking with him and having him draw sketches of what was actually there, that everything was okay. So my suggestion, I guess that's up to you to make that recommendation.
You can tell I drafted this morning before coffee because I forgot to add my recommendation, but my recommendation is closure on this case. So.
Oh, and his
I agree with that.
Yeah. So his report was adequate, and it was stamped and all that good stuff. Okay.
Yes, it was.
Okay. Go ahead, Frank.
I do have one question, Stephen. This has been going on for a while. Do you know for sure that he did these calculations prior to this issue coming up? Or did he do this in the last week? I'm being facetious, but did he do this last week knowing he's fixing to get a phone call? You know?
I don't think I have information on when the construction actually took place. The contractor installed the beam without any engineering design work. This engineer was called in to check it because there had been multiple contractors on this renovation job and no permits were pulled. So at some point, I guess the building inspector got involved and wanted to ask the contractor for a certified letter about the quality of the beam installation. Now, I did not get copies of any kind of calculation. I got a stamped letter saying that the engineer had reviewed the beam, the columns, and the support system.
It sounds like the letter was done at the request of the codes official at the time, way before this meeting. Is that correct?
That's correct. And the new homeowners, if it helps a little bit, the new homeowner, I've tried to speak with them. They don't understand what's happening at all. They don't want to be involved in this at all. So he would not have been able to get back in to, if he was to do that. Not doesn't mean you can't invent things, but regardless, he would not have been able to return to the property. They didn't even fully understand what was happening when I talked to them. So.
Did you have a follow-up to that? Rick does.
I have a question. How does this reflect on this engineer's record?
This engineer has no history, and in fact, well, they're pretty reputable in this area. That doesn't impact anything. I don't know anything beyond that. But I have had this individual serve, or at least come across my desk in the contractors world as someone who is an assistant on cases. So I'm not saying that should play into this. I think every case is taken separately, and I think even the best of us can make mistakes. But if that helps at all, this is someone with quite a large workload with no complaints.
No, my question is more to how does this impact his record that's on file? Not that I'm not opposed to what the recommendation may be. I want some clarity on if someone files this complaint, then how does that impact him moving forward?
Oh, I see. Yes. It will show that a complaint was filed, but it'll show that it was closed without action.
So he'll have to report this to Indiana or whoever.
No, since there was no action taken, and unless you're right, unless you would know more than me, unless that state has a rule where you have to report anytime a complaint is opened, which could be the case.
Yeah.
And at this point, he would already have been up for that responsibility. I don't know of that. It could be that jurisdictions do require the minute a complaint's open, you inform them. He would have already likely had to do that. But at this point, he could then follow back and say it was closed without merit and found meritless.
Okay, I just bring this up because of something that happened in my firm with Florida. There was a complaint and it was nothing. It was dismissed, and the state wanted some background information on it. The state of Florida has already purged it. All it is on his record, and it took an extra 3 months to get the licensure straightened out, which was a bunch of crap, if you excuse my French. And that's what I hate about these complaints, is that you get a complaint, you haven't done anything, but it's still on your record, and then you got to suffer through that with another state, which is just not fair. It is what it is, but I wish there was another way that we didn't have to have this on there, that you would have to say, yes, if they investigate me, it is on there, so therefore I've lied, and that in some states is a felony, which is blah blah blah. It's insane how this works. The bureaucracy of this. So if this guy didn't do anything, why do we have to put it on his record? That's a statement more than a question, and I wish there was something that we could do about that. So,
Shannon, were you going to say something? Because I was going to follow up.
I just wanted to add to also know that the office would add to NCARB and NCWS if the complaint needed to be added. So in this case, it wouldn't be.
And Rick, I'll follow that up within NCWS, and I think it was at the last annual meeting. Yeah, it was. There's a huge debate, which I'm sure happens within NCARB as well, about this piling on effect, where you because you have a jaywalking ticket here, it turns into a capital offense somewhere else. And I think there is a move within that organization, again, I'm sure others too, to try to mitigate that sometimes, because I forgot to call California and tell them about this the day that it happened. Well, that goes on your, and I'm just using but it goes on your record as somebody who's failure to report an offense. And really all it was is you were 2 days late in getting your continuing education in or something. And so I think there's a huge discussion going on how we mitigate that within the NCWS, because it is a problem, and it really does impact the registrants who do very, very minor infractions, if anything, across. So we need to make sure that we continue to bring that up on our national organizations and at national levels, with everything that we do, because that is a big deal. Because this will show up, but it just has to go through an extra aggravation to say, oh, it shows up, but it was closed and I didn't do anything wrong. And so your point's spot on. So, anything else?
Thank you for letting me vent.
All right. Do we have so we've got a recommendation to close? Do I have a motion to that effect?
I'll make a motion. Move to close without merit.
Is there a second?
Second.
Any more discussion? All in favor?
Aye.
All right. Very good. Thank you very much. If I can find where I am on the agenda, we'll go forward. Okay, rules on page 17.
I'm so sorry. I did have one more thing. I apologize. It's nothing formal, but it is legal report-esque. If you all may recall, we had an application denial case a couple meetings back, and it was appealed to Chancery Court. I'm happy to report that we were successful at the Chancery Court level. The actions of this board were upheld, and the Chancellor has required no further action. So we denied an engineer's license based on them having a complaint that wasn't addressed, where they had a court opinion in the case file saying that they had committed a Consumer Protection Act violation. And the engineer let the license expire fully and then came back to reapply, and this board denied it on the basis of that, in part on some of the complaint or information in that case file. And the Chancellor said that you all had a thorough discussion on the record and were within your authority. So wanted to give you that good report. So.
Thank you.
Next is page 17, rules, proposed rule filing form. Got that one.
Apologize. The pause was me recognizing that this was me. I think you have on your page 17, you have a set of rules that you can see, a proposed rule filing form. These rules were previously filed at the Secretary of State's office on August 9, 2018, and they became effective just last month on November 7, 2018. Do you all have any questions about these rules? If so, I can try to answer them right now, or I can, if not, I'll ask for a moment of time just to kind of come back and familiarize myself with them, because I know that you all had worked very extensively with Liz on these rules. And I don't know if I told you all, but since last meeting, Liz Goldstein, here's an update on Liz. Liz Goldstein was offered a position, and she took a job outside of the department with the NASBA, the National Association of State Board of Accountancy. Thank you, Sarah. So we were very excited that Liz was offered a position outside of the department in private practice in an area which she became an expert on here at the department. So that had happened just after a few weeks
to get
after.
married too.
And she got married, and so she wouldn't mind me telling you this, but she said, it's one of those things. She was like, it's almost like everything happens all at the same time. So it was a stressful decision for her to make. She told me in the end, and I told her that I really appreciated all the work that she had done in the department, also with this board over the last couple of years. So I felt like you all may have wanted to have known that. And I'm sorry I didn't announce it earlier. It just came in mind, but I thought about it the other day.
Are there any questions on the rules?
So you all had asked us previously when Liz came to you all to we went through a slightly complicated issue about, in essence, there were two set of rules for becoming effective at the same time that were amending the same section, and that had started through when we went to Joint Government Ops for a look in of the rules. Every month we go up there to talk to them about pending rules, and they had stayed a set of rules, and I think there was a question as whether or not that they're staying the rules going to actually take them out of the set of rules. And in dependency of all of that, this board actually met and had recommended amendments to the same rule. So we ended up having two different rules at the same time that were going up to the Secretary of State's office, and we came to you all last meeting about we had the opportunity to allow a future change to happen or to keep the status quo as to where we were at, and you all had said that you would like to keep the status quo, so we withdrew one portion of the rules, which you can see at the top of this filing, soon after the October meeting, and that rule that we withdrew right there was at 120.01-03, and so what you would see is on the red line, you would see the amendments is probably the better document to look at. You'll see that those would not go into effect. Because that amendment would not go into effect, the rule would be as it previously was, and it's our intent to come back to you all to add in that provision because you wanted that provision to be added in, but we just needed to do another rule filing to do that. So that was the intent of that, and we have not drafted that yet, but we intend to for you all.
So just to clarify, on page 26 of your iPad, the highlights that are in blue are the things that were omitted from the rule making at our request. I believe that's because we wanted the rest of it to go forward. Does that sound correct? Okay. On 27 of the iPads again, the same thing.
On page 27, the blue is actually showing up.
Yeah, but it's not included. That's what we had asked to have. We have to do another rulemaking hearing to have that included.
It shows up as being in the one we're looking at.
If you'll see on the I don't have the iPad, but on the first page of this rule filing form, you will see at the very top it says withdrawal of rules 120.0103 filed on October 19, 2018. That's stamped by the Secretary of State's office, which has that. And if we would pull if I pulled the effective rule, you all would see that change absolutely how it sits now.
Are there any questions? More questions? So what we will need to do is the next rulemaking, we will need to add this language back in to a proposed rule. That's correct.
Yes, that's what we have as the due out from the last meeting is that you all would want us to come forward with you with a new proposed rule that we would take the current rule 121.03 and amend it to add in that language, which has to do with the architectural associate language. What was the intent of it? So that's what we will do in the future.
And what about on page 27, the 2A, the 3 years experience? It's 2A, subsection 3. That would also need to be added. I'm trying to go back and forth here. Although that looks like that was approved.
So that was everything else in that rule in this filing became effective. What did not was just that one rule, which is back on 26. If you look back on 26 and you see 1AB, it looks like that one provision of B was not added in there, and that's what we would add in to the current rule.
Okay.
What you're looking at right there, that 1A, unless properly registered on the top of page 26, that is not the rule as it is right now. That was part of the confusion with the filing. So what you all had indicated is that the rules as amended that went to the GovOps before June is what you wanted, and that's what is current. That is what is the current rule right now, and I can see them on the Secretary of State's website right here. I apologize because I understand that this is confusing because you're not looking at the rule as it is now, as it became effective because we withdrew this one provision. But I think the takeaway is that top of page 26, 1B, notwithstanding subparagraph 1, we would come to you all with a new proposed rulemaking that would have that language in there and added into this rule.
I think our confusion slightly on the engineering side is on page 27 of the iPad, that is in blue. And that's actually been approved. The stuff that's in blue, the language that's in blue, has been approved by the Secretary of State, where we have subsection 3, and no partial credit will be awarded for experience, that has been approved. If you go back to page 22, I think that's right. That was improved in its entirety, but it's in blue on our iPads as if it has not been. So I think that's where we're having.
Yeah, I'm sorry. So the blue, maybe there's confusion. So on page 27, the blue that you see right there?
Yes.
It's blue underlined. Those were additions to the rule, and that is what the rule looks as now. I'm looking at it on the Secretary's. It's today, right now.
Okay.
Absolutely.
Okay.
So I'm sorry.
Okay.
That became effective on November 8th. And so the only thing that did not become effective on November 8th was the top of page 26 is the red line version, which is that rule, and I'll just refer to it as, I guess, -03. So we just took out that one little provision. We didn't take out all the other changes.
That was our confusion. Okay, I'm sorry about that. So we have to go back and get the architectural associate language again on a rulemaking hearing. Just the net of this. Okay. Questions besides me? Frank understands it, so that's good. Okay, good. All right. Thank you very much then. That's good on that. When do we have another rulemaking, and do we have other rules that we need to talk about prior to that? I don't know what we have.
Before we convene, for lunch, I'll make sure I have a spreadsheet that I have, and I'll make sure. But this is one board that I think always has a rulemaking going on, and I think we had 2 at one point in time. But I don't think we have anything outstanding. But I'll double check and make sure I have a spreadsheet here of all the rules that we have outstanding. But I think this is it. But I'll double check.
And I think historically we've waited till after legislative session to do that because they always come up with something that requires.
Oh yes, absolutely, and I think I have often with my programs found that we're doing multiple rulemakings at the time, and sometimes it's necessary, but and it does get a little bit confusing, especially if you attempt to change the same provision twice, which is kind of a no. It's kind of a no-no because you'll end up doing what we have done over the summer, and I'll admit that was our mistake that we should have caught.
Of course, I mean, again, we know what it is, and we're ready to move forward then. Plus, it just messed up the architect, so we really don't care about that.
No, so sorry. You do have I know what it was. You do have one more set of rules that I was working with just this week with Ashley, and that had to do with our lengthy discussion about the PDHs for the architects. And so we did make those changes that you all had asked us previously last month. We made those language changes. That would be by rulemaking hearing, and we have moved those through the process of being looked at and approved by the Attorney General's office so that we can schedule a rulemaking hearing. And I guess this is probably a good time to bring it up, if it is, Roxanne, about the date for that rulemaking hearing, when that would be. Do you have a preference of when that would be during your normal meeting time? Because I think in the past, what I have usually asked for, because I don't control when those would be approved by the Attorney General's office, the amount of time it would take. If they see one minor revision, it could take a couple weeks. I usually ask that the board authorize us to schedule it at the earliest meeting that possible on the timeline of it, because it has to be filed and sit for, I always say, 52 to 53 days at the Secretary of State's office prior to doing that. But if you all could authorize that, we would, at the earliest convenience, we would keep everyone obviously in the loop, that you wouldn't come into a board hearing. It would be on the agenda, but that would help us so that I don't have to come in and say, well, 2 months from now, would that work? I mean, when we could have done it earlier.
I
That,
think,
that
go ahead.
meeting is 6th and 7th of February, if the board is okay with that.
Well, I think, do we just need to go ahead and make the motion at the earliest convenience, at the earliest board meeting?
That would work, and then we would.
Then if it goes into April,
Yes,
then we're not.
and then
having
I would
to-
know the date that I would put the filing date on there, and then everybody in the public would have the notices when that date is, but that way I don't have to try to come to you all and make sure that that date would work for you before we notice the public.
Have any kind of discussion on that or a motion?
I make a motion that we approve, that we, that the earliest possible date, based on what legal can accommodate.
No. Have a second on that?
Second.
Any more discussion? All in favor say aye.
Aye.
Those opposed, and the ayes have it. All right. Good, thank you. And we go next to complaint data. Am I right? Yeah, page 39, Director's Report.
Yes, sir. We start on page 39. You kind of have three different reports for complaints, and I can walk us through it. This is still a work in progress. I hope to soon have a more permanent version of what this will look like, but I wanted to get you all the metrics and anything else we may want to look at. So on page 39, architects and engineers, these are the open complaints right now through the pipeline, and they are by profession. So the first two are architects, then you've got engineers, and at the bottom, one engineer intern. And the date is at the column to the far right as far as the aging it's at. So because they're by profession, you don't have it from oldest to newest, but you'll see the ones that are current, several of those were presented to you today. So the ones you would have heard would be there as well. And that's kind of an overview, and then the date at the bottom. So those are all the open complaints that we've got right now. And then the next page has the metrics that'll give you that 97 percentile. So for the month of October, for all of our professions, we're at 97.75, and 90% is where we want to be at least for that. And this takes into account the 180 days per case count.
Exactly what we need to be seeing. Very good, thank you.
Okay, good, thank you. And so
I
we
just-
will
are there any
have this
questions?
at a.
I'm sorry,
No,
were
you're
you
fine.
finished?
No, that's it with these two.
I was going to make sure we didn't
Yeah.
have any questions on that part of it. Go ahead, Kathy.
Yeah, I just, if you can remind us of these very, very old cases, I'm just don't remember these. What's going on there?
So on the description, that will tell us where it's sitting. So for example, I think there was one 2016. There it is. So under professional engineers, the 2016 case, that's under a formal case authorized. So it's living its course to be presented as a formal hearing if they haven't agreed. So that's the status of it. Does that help? So we likely often are going to have one of those cases where they don't sign the consent order and we go all the way to formal, and it's until we've got a judge and a calendar date to be able to hear it.
Yeah, I mean, what we have is, they're all in different, some of them have to get expert witnesses, some have to do different things, so some of these older ones probably are a little bit more, like you said, they didn't agree to a consent order, or they didn't agree to something, and so we're having to build a case, which does take some period of time to move forward with getting witnesses, getting the testimony lined up, getting judges lined up, and those kind of things. So, but we really only have two then.
You only have one that you
formal,
right,
that look like formal
Yes.
hearings are possible.
Yes.
Two more we're monitoring, and then others that have had the consent order has been sent but not returned.
Correct. And you only have literally one from November 22nd that hasn't been presented to you today. It's under staff review. That means they possibly have still more time to even answer. So,
Other questions? Good? All right, thank you. That looks good. Just know we're good. Okay.
page 41 and 42 has our all of 2018 of the administrative complaints that get the standard letters of warning. I will need, and the board has authorized us to go ahead and always close these right after we send those letters. I just need a motion to go ahead and make sure that that's still accurate.
Got a motion by Brian. Is there a second? Second. All those in favor say aye.
Aye.
Opposed? And we will let you send letters on those, please.
You. Okay, so moving past our complaint data to licensing, on page 43, you have all of our numbers, and you'll see there's really about only 2 months, maybe 2.5 months between the last time. But the board did say you want to see them at every meeting, so just keeping that in mind, we're going to see some months where the numbers look like they drop because we're comparing month to month. You haven't had the new exam folks and so forth, so I just didn't want anyone to necessarily start worrying. That's one of the drawbacks sometimes to seeing them every other month. But so the updates are for the architects, engineers, landscape architects, as well as interior designers, and the firms will probably update a couple times a year. If you've got any questions.
Patty?
These numbers include, and I think you all know that, all of our active, but they do also include those slightly expired, right, in that time frame where they can still get their license right back. It will not include anyone that's retired and can't practice because they're retired or invalid. They've asked to, they're just not using their license. Yes, ma'am.
Kathy?
I'd just like to note, I just did a quick calculation. So in 2 years, it's the number of total registrants has increased by more than 6%, which is pretty fast pace. I just want to recognize staff for the good job they do keeping up with all that. That's a lot of growth. It's a lot of effort. I'm not sure how you do it on a part-time basis. I think that's fabulous, but I just think we should continue to monitor the fact that registrant numbers just keep climbing, and that's an indication of the great economic climate in Tennessee, which is fabulous. But it also means that the burden to maintain an oversight for the health, safety, and welfare of the public continues to climb at the same pace.
Comment. All right. Any more questions? All right, Roxanne, let's move on to financial data then.
Thank you. And this is the promised 4-year financial numbers that you can see on your iPads on page 44. So this is the 4-year recap. We can look at the reserves at the very bottom. And I apologize, I just now noticed that the page number is sort of covering our $2 million plus something that's left when we do the final reserve. So I'll have to make sure that the iPads don't do that next time or shrink the page a little bit. But we're obviously in a good state, which is the reason that we addressed kind of the fees and reducing and what have you. But so we've gone from $1,000,005 at the end of fiscal year 14-15 to $2,080 something. Does that sound right? Oh, it's right above it. I'm sorry, $2,081. So I can see it. I was worried about that bottom page. So slowly we will start seeing minor changes with the fee that we have put into place, and I think the rules that are in the pipeline include the second round of fee reductions that we had discussed, but they're not in effect yet.
And correct me if I'm wrong, but that also includes in that same period of time going from 2014 to 2018, we've increased grants from around 200,000 to now 350. So we've actually gone up about $150,000 in our grant distribution to universities, and then at the same time continue to increase our reserve, which is, again, you all do a great job of helping us keep up with our dollars and keeping it as lean as it needs to be, and that money's able to go back to our students to keep the profession, all professions perpetuated in the future, so that's good. I don't know if
And then on the following page, if there were no questions on the historical, the following page is that analysis that we will get each month. So far we've closed July, August, and September. When I had to work on these, I did not have numbers for October. We have them now. And so I'll kind of lump September and October. We are ending up with a shortage, and the main reason is we had a lot of our technology invoices hit us those 2 months. Upgrades in the system, which is, I think, although not perfect, I think it's working well. We're adding more and more things to the online process that the licensees can do. We have those things that can be streamlined and centralized, such as the calls and the emails, and being impacted that way. So September and October are higher, but they will not, I don't believe, impact us in any way for the ending reserves to still be on that good trend. But those 2 months were a little bit higher. We should get back on track. And then we will be adding some lines to the actual expenses. if you look at September, for example, when we ended up with 20,640 short, if you will, that the lines on the expenses are going to give us a little bit better of a breakdown. We're going to have technology as its own line because sometimes just looking at it as a cost back is a confusing line if there's too much in it. So I think you'll keep getting a little bit more detail in this report to help you. And then the last page just does break down, if you can expand it to read it better, kind of the different categories for each of the months. And that's where, if you look at the last one in September, there's that increase to $46,598. That's kind of what I'm talking about. That has a lot of the technology, one-time adjustments and bills and so forth in there. So.
Sorry.
Yes, Blair.
I'm really sorry.
You're
hold
great.
it. Okay, I'll hold it.
Yes.
Right there.
Yes, Blair.
All right, Blair, since we've all.
Now that I have your attention.
Very effective.
Sorry.
Very effective.
Roxanna, back on 45, just want to make sure that this surplus deficit report, that also includes landscape architects?
Yes, this is all. So all
Okay,
four
well,
of our
It
professions
does not
are lumped.
mention at the top, it mentions
Oh.
we are absent up there, so.
Thank you.
Just want to make sure
I don't
that
think
we're
we've
included.
noticed it in any of the other reports, so I appreciate you pointing that out.
Sure.
It's all four, yes. We will add that.
Thank you.
That was worse.
Had to get your attention. Scared me too.
All right. Again, good job. Financially, it looks like everything is moving in the right direction, and I think our fee reductions and stuff are on the right track, and then we can continue to look at some of those going forward, as well as hopefully being able to impact the grants a little bit more in the upcoming days and years. So, okay. All right. Next one is proposed travel.
Yes, and just to add, because you mentioned, and I have in my notes, on the proposed grants, that information is part of last meeting's follow-up I sent on to be reviewed and approved through the right channels and so forth. So that's on its course. And if there are any updates or questions that we have, I'd bring them to you in February. So far, I haven't heard anything else. So we did say at the last meeting that we would discuss 2019 dates for travel, and I did receive in advance Frank's items. We can discuss his first since I have them in front of me, or we can just make sure that we cover any dates and times that we have. Yes.
I have one for the CIDQ meeting. It's November the 7th through the 9th in San Antonio, Texas.
Is this?
It's the CIDQ.
Okay, perfect. Thank you. And on the email that I have from Frank, he's got the NCARB 2019 meetings. Those are the regional meeting that we've been talking about a few times in here in Nashville. That is March 8th and 9th. Then the annual one is in D.C. in June, just June 19th and 22nd. Those, are we wanting the three members going? What, do we want to wait till we're closer to that? Do we want to go ahead and move the justification to approve these?
They include the three members and
staff.
and a staff person.
And
Maybe two.
maybe two, because typically in that, at least in the annual meeting, the states have the executive directors and legal there with the board members, if that's possible.
I think it'd be a really good one if we could get two staff people for it.
And the one in Nashville should not be a problem. I think one of the concerns that I know I've discussed with different programs with legal traveling with the executive director, but definitely with legal, because of the allocation on expenses, all of their time then is absorbed at a much more time is absorbed by the program. So we're a little bit more cautious if the need, but especially with Ashley being new, we talked about this at the engineering committee meeting yesterday, is getting her to these meetings as soon as possible so she can catch on. So the Nashville one works out perfectly because without a doubt, both she and I will be able to be there.
It's here.
Right.
So that's great.
That's exactly right.
So, yeah, I guess then the motion might be for 4, or,
Members and one or both of us, depending on.
yes, correct, yeah, that would be perfect.
If we don't do an alternate delegate to my meeting, then that would help offset costs for her to go to this one, which I think would be good for her to do.
Okay. And yesterday, we discussed, and the engineering committee voted on the Southern Zone 1 for NCWS, so we elected those. And then the annual in August. Any other meetings that we need to be aware of and kind of put on the radar?
Yeah, the only other, we've got the annual meeting, which is August the 14th through the 17th, and it's in D.C.
WS is in DC? Okay, I did not notice that. Okay.
So, I believe that's one that we ought. Yeah, I mean, I think we should ask for.
We wanted the state to pay for it.
Well, that's in that's the zone meeting. Southern.
Okay.
Yeah. Yeah. But I think let's go back to the Southern Zone meeting. We wanted the 3 funded plus 2 others. Is that what we talked about?
That's what we talked about.
And then for the, I would ask for the same thing for the August 14th through 17th annual meeting. And Roxanne, I know we talked yesterday about possibly you and Ashley switching or something, one going to one or whatever. And we need to kind of talk about, let's look at doing that. However that works. I would love to have both of you, but I mean, if that's not possible, then, and again, being in D.C., I think it makes it to where, I would probably, if I win, I would drive. I'm not going to take it.
I think you're not going to go south to go north?
Long story. I was coming back from Europe, and they left me at one of those dang airports up there forever, and I
left me.
But anyway, I think that's the only, August 14th through the 17th. I think that's the only other one we would have in 2019.
Roxana, we also have the ASLA meeting in 2019. I believe it's in August. It's in November. And then CLARB is also, which you are also invited to, is also in September, I believe. I don't have the exact date. I'm looking for it right now.
Well, and if you get them later, if you'll send them to me. But the same thing for those particular 2, the board would agree that you would be going, and if possible, and we're approved, one other person. Is that about right? Okay.
Yes.
Thank you. I think we have all the organizations, and if anything is missing, let me know. We'll start the justifications as soon as possible, just so I can give everyone an update. You can put your calendars.
Ricky?
Yes.
I just want to make sure I understand right now for the zone meeting for NCEES, we're definitely the 3 funded members are going. But right now, we have to ask permission for Ashley to go, or either Ashley or you, but
Correct, and I think on the funded, they will fund the director, anyone representing the board, if I'm remembering this correct. I will ask and see if Ashley, being new, can be that funded person, especially for the Southern Zone, to get her familiar with everything sooner.
okay. So
plan.
we're expecting
Yes.
that at least 4
Possibly
would go.
4,
Okay,
yes,
good.
Yes, in which case the approver then is one additional paid member, but yeah. Okay. Good. Welcome, thank you.
Excuse me.
Yes.
Back to our meeting in Nashville. That actually is the 6th, 7th, 8th, and 9th.
Oh.
Yeah. So
Yeah, I think in my email, I
Yeah.
tell you that.
You had the 8th through the 9th, but
They call
6th.
them, they call them travel days.
Yeah, Wednesday would be the travel day, the
Oh, yeah.
6th.
Okay.
And then I think is the 6th, the first, yeah, 6th is the first meeting that evening.
Okay.
So, and then we will adjourn and be out here on that
Okay.
Sunday.
Okay.
Yeah,
And
just-
that's almost here, so yes, we're going to put this through.
Yeah, I just want to make sure, because I thought that sounded odd.
Okay.
Okay.
Perfect.
Thank you.
Thank you.
You know, I was going to wait till later, but maybe I will just left the NCAR exam committee meeting, and they're definitely making a big deal about Nashville. I think you guys know that's where it started. In 1919, there was a AIA meeting, and a group broke away from the Hermitage Hotel and walked down the street to start NCARB. So they are, still looking for any kind of history that we can add to it, and there is a lot of buzz about coming to Nashville. So I would, invite even all of you guys up there to maybe drop in, just if you can. I think it'll be something that to be more of a host to it all and kind of get a good feel for it. It's still a buzz, and of course we're really excited about the 100th, which Roxanne, I think you'll definitely appreciate that one. But so anyway, I was going to make the statement later since we've been talking about NCARB in Nashville so much.
I would like to also say I didn't realize they were making those kinds of decisions at the Hermitage way back then.
Well, they weren't. They left the Hermitage, actually.
Oh, okay. I stand corrected. Excuse me.
The rumor is they went down to a bar, but unfortunately it was prohibition, so they're not sure exactly where they.
Well, we'll just leave that like that.
Were you not there?
In spirit. Very early in spirit.
So you're saying that your profession was started in a drunken frenzy is what we're understanding.
I'm at prohibition here now.
But I agree with Brian. I think as we get, I think it's in May, correct? March.
March, yes.
We might want to look in February and see about what kind of, presence that you may need from the board, or just, I think that would be a good sign to show our support. And especially for everybody here in Nashville, it's a drop-off kind of thing. So, Compass tickets or whatever we need to do to get there, and probably a lot of people can show up. That would be a good thing.
One thing we have said in the past to NCARB is that we are going to try to get some kind of proclamation from, or acclamation, whatever you call it, from the governor's office recognizing contribution. And we volunteered different sites for tours and that kind of thing. So we are in touch with the committee, and Roxanne's been doing some of that as well. So, but anything that we can do to show our interest as a board, we would appreciate that. So thank you.
Along those lines, I've got in my notes two quick updates. We do need, Chairman Campbell, this is on your piece, on NCWS Board of Directors Assembly. We need to have a motion for you to attend that, and I do have an email with some details. They had sent out an invitation on this meeting, and it is in Atlanta?
Atlanta, yeah.
January, is that correct? Oh, no, January is the deadline for
It's
registration. It's February.
Something, I think.
Yes.
Hold on just a minute, and I'll find it.
And so we would need a motion, and thank you for being able to go to it as the chair, Robert. So we will, I think it looks so far like you'll be the only one going, and then you can give us feedback on the meeting for next year and keep an eye on that.
It's 8th, 9th, and 10th. And what I would, if I can get approval to go all 3 days, I think we still need to, and maybe Roxana, this is something better if you reach out and see if I could go on your behalf to the NBA or something, and that way I can just sit in here and listen to all of what's going on with the NBAs as well as the board presidents.
They had approved it. I think we sent an email early on
Okay.
to find out if I couldn't make it, and they said, oh, no, as long as, you've got representation to be, and are okay sitting through those meetings and not bored to death.
Well, I mean, it's a good way to get
Yes.
just kind of an advance warning on what may be coming up for the zone meeting and other things, because a lot of those, I think that meeting spurs some of those questions. So, to board president and
What is this meeting? What's it called?
Called the NCAAS Board President's Assembly and Education. And it's a 2-day, if you're a board chairman and an MBA, they usually have those or their representatives to just talk about the day for each one of them, different things. And I think we used to attend, I think it's been a few years since we've done. Something to ask for approval to go. Again, I'm going to drive down there.
I'd like to make a motion that Mr. Campbell be approved to attend the NCEES Board President's Assembly in, is it January or February? February of 2019
through the 10th, yeah.
in Atlanta.
Second. Discussion? All in favor?
Aye.
I just want to see the receipts from that to make sure you hadn't spent all your time at the varsity.
Yes. If I spend all my time at the varsity, you'll find my name somewhere else, probably.
On a tombstone, probably.
Probably, yeah.
Okay, so I think we've got that done. We'll put that through, and then, Robert, I'll let you know if we need anything else. I appreciate that.
Thank you.
Another item to follow up from the October meeting I have here. The board had asked for some feedback from the universities after our October meeting to find out if they would be interested or what their thoughts were on possibly meeting more often as opposed to just every other year. So I sent that out with the thank you to all the universities for coming and everything that they do on behalf of for the students and so forth, and did pose the question, did this work out? We had interesting conversations and so forth. And so I have emails from 4 of the universities, Vanderbilt, University of Memphis, University of Tennessee in Knoxville, and then Christian Brothers. And all 4 deans said that they enjoyed the meeting very much and would very much be interested in having those conversations more often than every other year. The rest I didn't hear from. That maybe that they wouldn't be interested, but again, just going on the communication here with the 4, it looks like they would be interested. So it's something to think about if when we come to the 3-day meeting, we want to send out an extra invite for those that are interested, especially the ones that have responded and said, yes, this was worthwhile, it's a good communication, we would want to be able to be there.
I'd like to recommend that we do exactly that, and we do it sufficiently in advance to ensure that they can get it on their calendars and be here. Chris is also here from Lipscomb, who maybe did not reply, but I think my understanding is Lipscomb has the same level of interest in doing that also.
And let me, along those lines, and maybe with the universities too, it may be something, Roxana, where we could, and the only thing about this space is it is a little limited when it comes to audio-visual space or capability. We might be able to have those sessions maybe every other year that are more of a question and answer, and maybe some of the audio-visual capabilities where we could talk to each other while they're in another location. Just something to think about, because we don't necessarily want to have a formal presentation but we would like to have a discussion of, hey, what's going on in your world, what's going on in ours. And that may not be something that's worth driving, say, from Knoxville or Memphis to Nashville. It may be easier to do FaceTime or whatever we do just to have everybody talk, but I don't think we have that capability here. Chris, you all may have it. I think I've heard you say it, and that's one of the reasons it kind of popped in my head. And I'm sure Vanderbilt, some of the other places around probably have that capability, which may help lessen the burden on just the travel aspect and still be able to have a pretty good flow of information. Just something to consider as we look ahead.
And we do have the option, I don't think with this board, at least since I've been doing the meetings, I've had it, but with several other programs I do, to call in and participate electronically. And so as the building's being remodeled, I don't know that that will impact these rooms, but the floors upstairs definitely have been impacted and we're moving. So I'll keep an eye on that, but we definitely can have anyone, and as many as I don't think there's a limit, it's at least 50, call in. So that could be an option for us to do. And then for October, I know Chris and I have talked about, they've been very courteous and brought up that maybe holding it at their university in October.
And I think the call-in's great, but I mean, I think
It's not the
again,
same.
some of the face-to-face stuff, and we've died twice,
Like
but
the
I think
WebEx.
some of the face-to-face stuff is maybe a little bit more helpful just to be able to encourage interaction. So, anyway, Susan?
Yeah, I wanted to go back to, having them here. Many times I've heard the same comments of, they learn what the other universities are doing and they're collaborating, and had they not been here to see that, they wouldn't have known about it. And they end up sharing professors because they can't all hire the one person that can do that one course. So I think the interaction is good from multiple levels, Part of the grant committee charge is for them to show us what they're doing with the money. So they don't have to give us a 20-minute dissertation, but, at the same time, we try to limit it to 5 minutes, and sometimes it doesn't go over. But I think getting them here more often is a good thing. So.
Chris, don't mind, since I went ahead and volunteered you for everything.
I just wanted to make a comment that one thing that I noticed this year that was kind of lacking from previous years was just the gathering of everyone in a around a table where we could talk to each other and talk to you all. And I know that in the past when we met, we've met it outside at the parks and so on, that we had that opportunity to sit around and converse more. And I think that was lacking this year. The universities kind of sat in their little pods out here, made their presentation. We had a little bit of time when we ate to talk, but otherwise we didn't really have that community, I didn't think. So I don't know how we could do that better, or y'all could do that better. We can do it together better. Maybe at the university where we've got more room to spread out and to do that and spend the time would be nice. That's the only comments I had.
Oh, and I think that's an accurate comment and a good comment because, again, I know we had our restrictions, but I think just being able to get together and spend those 5 minutes talking, out in the hall or whatever, or in a corner somewhere, are really helpful to a lot of us to understand what we're doing and how that may impact the next generation of engineers or vice versa. So I think that's a very good comment. Kathy?
Yeah, I think that was it would be 3 years ago or whenever it was, there was a lot more of that. And totally agree with you. We were physically segregated from one another, and so we seemed to be emotionally segregated from one another and couldn't really connect. So I totally agree with that point. And I also would say that when we invite the representatives to come, if we could give them more input on what we want them to present, so that they don't. I felt like several of them got up and they were embarrassed because they said, "Oh, I didn't know I was supposed to tell you more about my program. I just came to tell you more about that project, that fund." And I don't want to put them on the spot like that because then they don't want to come back because they were embarrassed. So if we could give more guidelines on what we want them to tell us so that they all come prepared to do exactly the same, just for their sake, not for my sake. But, some of them were more informal than others, and some were more project-focused than others, and several of them apologized. And I felt like that was just not the way we would want them to feel.
So we give them the same information, which is you're presenting on that project so that it doesn't last all day. Then they decide and bring whatever, we don't view it. So it is sort of out of our control if they're going to go on and talk about the university or bring a major presentation versus minor. We keep it, but the board can decide. I mean, we can put, here are the only 3 things you are to bring and talk about. But in general, we try to keep it to it being about the grant and just that. The other universities that, may add more.
And the information that the other universities gave was actually very
Absolutely.
useful.
Absolutely.
I mean, there's so many of them out there. It refreshes your memory on what they focus on and what their program's all about, and the constituents that they serve, et cetera, et cetera. I thought it was all very useful information. And I guess if we're going to let some of them do that, then we need to make sure that we tell all of them that they can do that, is kind of my point. Does that make sense?
It does, and I think we probably ought to give them a time frame for
Give 'em a
doing
time
that
frame.
component. But
Right.
there's lots of other items that would be agenda items for discussions with the universities beyond just what they use to do their what they use their grant money for. That I would enjoy a little more extended time as part of the agenda beyond just those presentations. I think we ought to limit the presentations to maybe
Limit it, yeah.
10 minutes or so each,
Yeah.
or less if
Please
possible.
limit your introduction to your program to not more than 90 seconds, and spin the vocal, or some that kind of guideline. I guess that's what I'm saying,
Yeah,
is
yeah.
give them that kind of feedback so that they come prepared and don't feel surprised that they had a greater opportunity than they took advantage of.
Correct. And then, we're going to meet 2 months before we have that meeting. I'd like for us to set some agenda items that they would be prepared to talk about outside of just the grant awards, and not just about their university and what they do and how many students they have, but things like decoupling and the potential impact, or other elements that we may think of that would be a good part of an agenda discussion that we could have some amount of time to interact with them on.
I think the only thing to keep in mind with that, and I like that because a couple did want agenda items, and my thought was that we didn't want to set it that stringent and that specific. But if we give them agenda items and a time frame, most were concerned of getting out of here early enough to be able to drive home. They didn't stay the night, and so they really needed to be on the road by 1 or 1:30 to. And if we make it longer, I just need us to keep that in mind, that they would be needing to get the university's approval to stay the night or come so forth.
One of the challenges that we had was there's been a change of staff. There have been people retiring. Emails were not current. So in defense of Roxanne, she went on a dog hunt trying to track people down just to get them. And then when I found out the ones she couldn't, then I was, going after them with the information I had. So we've got to make sure we've got current information from all of them. And I believe we had them to sign an updated sheet.
We did, but it may change next month.
Yeah, that's
So
true. But anyway. And obviously, UT's got 2 people that were retiring that's been significant to attend our meetings. So anyway, as we get closer to that, we're going to need everybody's help to make sure, we've got information, or at least know somebody there to make sure they get it. Because a lot of these people found out the morning or the day before that they were going to come in someone else's place. So that's hard on anybody, to your point, Kathy. So.
Oh, go ahead.
And I may be reiterating something, but what I remember that was valuable, we have the presentations, and that's information for us. But I remember in the past, we would have breakout sessions with the interior design group, with the engineers, with the architects, with the landscape architects. And in those breakout sessions, we would discuss pertinent issues that we're dealing with at that time. And it seemed like that was really valuable to get, a reaction from the university people, because they're teaching the new students, what they feel as far as what we're doing. Some of it they don't like, but, I think that was good for us to get some feedback directly from them. And like somebody said, the closest we had to that was eating lunch, and you kind of talked to a couple of people. But really having an organized breakout session really, I thought was useful.
We only broke out into 2 rooms. This room was the engineers, and they chose to bring everybody to this table and sort of enjoyed and all spoke because they all had mics and were at this table. And then the other breakout room was next door. So the problem was we lost 2 huge meeting rooms because of the construction of the building. The plan was to have 4 or 5, so I agree with you.
And I guess part of the question there is, does everybody have to be mic'd and recorded?
Yes.
In those breakout meetings?
Yes.
Well, this is just a comment, but we had grants totaling $350,000. That is one out of every $4 that we spent last year. More than 25% of our expenditures went to that program. So I think it deserves substantially more of our own investment of time as compared to all the other things that we do. So let's not short-circuit ourselves with regard to understanding what we get back and what the state of Tennessee gets back from that program, and take advantage of that. That's a lot of money.
All right, our next, are we cool with that? But I think, again, I know we were where we were, but I think we can improve, and I think it sounds like it's value added for everybody. So as long as it's value added, and good point, Kathy, we do spend a lot of money, and it's good money. I mean, it's good money. So I think that's a great thing. Let's see here. We'll let committee reports, and I think Ricky's got engineering committee. Let me ask a question in its general discussion. How do we want to make those items part of his report, since we talked about those, or the engineering definitions, decoupling, or talk about those separately?
I think that would be perfect, and they're on the iPad sort of in this order, so that if the engineering committee goes first, and that's the only one that met yesterday, I think that's great, because you all covered so much of it. If I can add before we move on, just a quick note. I printed in paper for everyone to take home the final distribution of the grants as we spoke about it. We voted on it and got them done at the last meeting, and then I got, thanks to Susan and Alton's, those good reports, but I did send them both kind of an updated. Once the contracting folks started on it, the math didn't all jive with the final dollar amount for the final special grant. They ended up with $7,272. So I wanted to hand that in paper for everybody to know, since we're moving forward with the contracts. It'd make me feel better if everybody had those. But other than that, yes, we're on to the committees, and if you're good, Ricky, with... Oh, quick update. So on the agenda, I did have one update, and it's nothing on the agenda. This is regarding the CIDQ, and this is the engineering side. They've done a major overhaul to their website, and the interface is great. We had Wanda and Francis do the training so that they can add things, look up things. So they both participated, did the training, and really gave me good feedback. And so they were very excited. I just wanted to say that. Thank you.
Okay, well, I'll go through a report, and then if there's other things people want to cover about these topics, maybe we can do that, but I'll go through it. It was a kind of a beefy committee meeting yesterday. Started out, we reviewed applications, engineer applications, and in doing so, we confirmed that a potential applicant from out of state who passed the PE test before having 4 years of progressive experience could not obtain their initial PE license in Tennessee, because our Tennessee laws don't allow this, which would be decoupling. Our laws require 4 years of progressive experience before taking the PE test. So, but we did also, in discussing it, we confirmed that the applicant could get a license in another state and then apply to Tennessee for comedy, and that would be fine. That would meet our laws and rules. So that's, I think, since we've been talking about decoupling, that's the first case that's come to us like that, and we've discussed it for a while, and we expect more to come. We also discussed the charge that we now have to write a definition of engineering, and Ashley gathered definitions from all the states, including, I think it was 4 states that have no definition. 46 do. we're in the same boat as California and Hawaii in not having a definition. So I'm not sure what that says, but Kathy Ware is going to create a draft for our review, and we talked about paying attention to incidental architecture and needing to coordinate with our architects on the board on that, and also having a section in there on engineering surveying and making sure that we coordinate with the definition of surveying, which is in our state laws right now. We also fielded are in the process of fielding some questions that have come to Roxana and Wanda by email. And one sounded kind of innocent, a question about whether a registered PE who does some work that is exempted from needing a registrant, if they do some work, would they need to seal the documents? And it sounds like kind of an innocent question, but in looking at the laws and rules, we weren't 100% on the board. It wasn't unanimous, but most of the board members felt like the rules didn't really say that a registered engineer could not stamp something they did. It just says when a registered professional architect or engineer does something in terms of plans, specs, or a report, it needs to be sealed, and it doesn't say unless exempt. So, but it was left as an open question because it wasn't unanimous that was the case, and so we've asked Ashley to look at that from a legal standpoint, to look at our laws and rules and see what we think the legally where we are with that. And that's important because right now we know there are a lot of reports being done that aren't sealed, and we know that there's work being done by people who are registered engineers in industry where the assumption is they're under the industrial exemption. That if we interpret this, that their work has to be sealed, whether the work they're doing is exempted or not. There would be a lot of education that would need to happen, I think, because we don't think that we suspect that the practice out there is that a lot is being done without being sealed. So it seems like kind of an innocent question, and the two exemptions are for structures, less than 3 stories and 5,000 square feet, and the industrial exemption. Yes.
So, question to the architects: if you've got a building that's 3 stories or less, 5,000 square foot, and it's designed by an architect, would your expectation be that the architect stamp it? Because it could be done by a contractor, right? I mean, it can be done by anybody. But your expectation, if an architect does that, even though it's exempt from stamping, that they would still go ahead and stamp it? Or is it, since it's exempt, it's just exempt and you don't have to stamp it? And that's the crux of the whole issue is, if it's done by a professional, even if it's under an exemption, and it goes back to, it would be under you all too. I mean, that sounds kind of crazy, but
I think the question is it required by law or not? I mean, if you're a registered engineer and you write a report, why not seal it? That's question number one. I mean, and if it's not required to be sealed, what would your reason be to not put your seal on it? Are you saying it's less than what would require a seal? But to answer your question, I've done a lot of projects that are not required to have a seal that I've sealed, just because I'm a registered architect. But that doesn't mean I'm having to do that because there's a law that says I do. So I guess the question is really legally what is required. And I think that's what you're saying.
I just wanted to hear what you all had on the record. Susan?
Do you all recall our last formal hearing? We had an architect that had not stamped many of the drawings that he was working with, and the local authorities turned him in, and then there was other mitigating factors that made it a very long, stressful day. But anyway, I think if we're going to be consistent, we need to be it across the board so that our plans reviewers and our local codes officials have something, definite. So that's my thought.
So in the discussion yesterday, one of the issues that contributes to the confusion is there's a lot of reports as opposed to plans that would be in question as to whether or not they're required to be sealed. So there are, in the environmental world in particular, lots of reporting that goes on that is done by environmental professionals that are not PEs or architects or anything else. And so those documents are they're not provided by registrants. They clearly are not sealed by a registrant. And in some cases, registrants are duly authorized, if you will. They're educated and can provide those reports. So if there are some people who can issue those reports who are not registrants, and some people who can issue those reports who are registrants, just because they're a registrant, do they need to seal the report when someone else would not have to? That was more of the issue as opposed to plans. So, that was my issue relative to the conversation yesterday, was just, that I'm sure that there is an assumption by many registrants that if they're issuing documents that don't fall under the signature and seal requirements, they aren't putting a signature and a seal on it. They're not noting. Sometimes they don't even note that they're a PE. They might have a name. They might be a PE, but when they go to sign the document, they don't, for instance, they say Susan Ballard, not Susan Ballard PE. And they don't seal the document because it's not required to be sealed. So I think the issue is there's a signature seal requirement for the person, and there's a signature seal requirement for the document that's produced. And it appears that maybe there's some conflict in the law. So which one governs?
Rick, I'm sorry, I thought you were done.
No.
If you're not required by law to seal something, you don't have to seal it. If you don't feel responsible, you're still liable for a lawsuit. But if there's something, if I have an opinion on something, I'm not going to sign it. Or stamp it. But I don't think that you have to make people. I don't care what circumstance it is. You can't make me stamp something if I'm exempt from it. So I don't think that it's an issue. Are we talking about saying we should all make everybody do that? We can't do that because it's not legal.
With regard to that, so like you said, you have an opinions of. Do y'all ever do opinion of cost letters? Was that something that you?
Like a budget?
Yeah.
Sure.
Do you seal that?
No.
Okay.
I sign it.
Okay.
If you want a letter, I'll send you a letter. But if you ask me to sign something and seal it, then I'm going to adjust my fee to cover that because it becomes a different liability issue. So that's a business decision. And we've talked about this before. If I design something, I'm going to design it like I'm going to seal it because that's my responsibility. However, if I don't have to and I don't want to, then you can't make me.
And I think, and the reason I ask is to get that on so that Ashley could hear some of this conversation, because Tennessee Code Annotated says that we will, as registrants, you'll seal reports. Okay, it does specifically, but our rule does not say that. But also in our seal rule, it says if you're a registrant, you will seal this, this, and this, and there is no exemption. There's nothing in our seals rule that says unless it's exempted, and Ricky said that very well. And so we need to come to some. This is could be a big enough deal. Can continue. I mean, we're already having disagreement among ourselves, and we're 9 people. So the disagreement that's in the industry is even a bigger thing, which could lead to other issues down the road. And I think we need to put a stake in it somewhere on whatever that is, because the questions the person asked were really great questions yesterday, and got us thinking, because the two don't really equal out. And I don't know that we're, by what's printed, we may not be given the flexibility one way or the other. So that's, if you're a registrant, you're a registrant, you need to proclaim that you're a registrant on everything that you produce. I mean, but we need to have some clarification. Steve?
Let's take this one little step farther. If a structure is not required to be sealed, we get a complaint about a registrant for a minor part of a structure that didn't have to be sealed, what do we do with that? Are we saying that engineering or architectural work, since it's on an exempt structure, is not under the purview of the board, or is it under the purview of the board? And a good example of that is that beam we just talked about earlier. That was in a single-family residential house. It was single story.
I mean, and that's where we end up getting. I mean, we're getting complaints based on that, but it's in an exempt situation. And again, I think we're going to get more. We need to put a stake in this one way or the other, because it does come up. I mean, we didn't discipline the person, but there was a potential to discipline a person for violating.
Before.
Yeah, we have before. That's exactly right. I mean, so, you know, that.
I don't want to belabor this point, but what is a report? You know, is it a cost estimate? You know, the way I see it, a report that involves the health, safety, and welfare that we're providing our expertise, that needs to be signed, whether it's $5 or $50 million. I'm saying there's difference in, I guess, to me, it's like how you define what a report is in the first place. And I'm not sure. I think a cost estimate is a report, a technical report.
I think we need to come to some conclusion on some of that to be able to give better guidance in a lot of different areas as well, because it's come great questions by whoever sent those in, and it pointed out some weaknesses that I think we have in the difference between the law and the rules and things that we really probably need to hammer those out. So, I mean, whoever sent those in, that was again, I think it just pointed out some real weaknesses that we have, and maybe some tightening up we need to do, because it could create very, very bad situations going forward. So, Ricky.
Just two more thoughts for your consideration.
I'm sorry I interrupted your
No, that's all right.
report,
And I agree with you. I don't think regular correspondence in the course of a job would be a report. I think a report would be something that a professional or somebody has been has negotiated and been approved to do. You know, it's a delivery that is part of a contract, a report. So I agree with you. That needs to be fleshed out. And the other idea that came out, because before the discussion yesterday, I had thought that something exempted wouldn't really need to be stamped, just exactly what Rick expressed. But I can see that there is some value in the public knowing that whoever did this work is a registered architect or engineer, that is, when it comes down to it, that should be the first test, is this of value? Does this protect the public health, safety, welfare? And the public knowing that a registered somebody did the work is valuable, whether it was on something that's exempted or not. But it all comes down, I think, to legally what do our laws and rules say to do right now, and so that's kind of where it stands. And it brought out this issue that, just to kind of reiterate, our laws say plans, specs, and reports, and the rule just says plans and specs. And so we need to bring those in to be consistent. It would help our registrants to have that word reports added under the rules. So that was the discussion. And then moving on from there, we talked about the Southern Zone meeting, the attendance that we've already touched on, and last and probably most significant, the committee elected Alton Heathcote to be the next engineering committee chair. It wasn't quite a coup, but it was a very popular move, and he'll start. He'll start with our first meeting in 2019, which seemed appropriate. So, congratulations, Alton. End of report.
I think we hit on decoupling as well as the engineering definitions, which we've asked Ashley also to look at how we're able to possibly get you and Kathy together a little bit as you start to flesh out these definitions on a instead of having to do them. Discuss that a little bit more.
I'd say it was interesting reading all of those.
Yes.
It's like some states, it's like it takes 5 pages to say what an engineer is, and some states it's like a paragraph. I prefer the paragraph, but somewhere in between probably is where.
Yeah, we agree.
Tony, since you're here, what do you suggest in terms of the ability for less than the full board discussion on these items?
I know I anticipated this question had come up, and so you've asked for a suggestion. So the legal answer is that under the Tennessee Open Meetings Act, this is a governing body, and a meeting is a meeting, almost using the word meeting, is 2 more persons in that body that are having discussions about board matters and issues, and all of those are required legally to be open to the public so that they may see and listen and hear the deliberations as to how decisions are being made. Since this board is an arm of the executive branch in how it administers things, the legislature has required them to be open. So what I've seen in the past, when you're dealing with complicated issues or matters or whatever that requires a vast amount of discussion, is we have seen either through a normal committee or a special committee is set up, and the head of the committee will put on there, they will dole out the tasks to members who are going to look at this and say, this is our agenda of the things that we're going to look at, and these are the do-outs that we need at our next meeting in order to flesh out what your ideas and thoughts are on these things. So it is I'm not saying it's easy, it's very difficult to do that, but I have seen it before in the past where, for instance, what we need to do is probably pare this down, either give us 10 examples, everybody look at bring 10 examples that you like, that you think that are close, or bring to the table what you think are good provisions that would help us throughout this, and everybody would individually distill that and then bring that back and have that discussion based on how the topic was originally formulated to kind of, I guess, throw out those things that you all don't want to look at so that you can pinpoint in on the issue. But there is not allowed under the Open Meetings Act for any 2 members of a board to get together and discuss board business, either via telephone, email, or in person, so that they can bring ideas back to a board and tell them what their process was, so that they can get matters done more efficiently. So I have seen it in the past. I'm not making this suggestion, but I've seen it in the past where they could have a special committee that does these things, and they would say, oh, well, the special committee on selecting definition X is going to have a special meeting over the telephone on December 16th, starting at 8 a.m. for an unknown amount of time. It'll be a telephonic meeting where they will be on the phone, and it will be broadcasted out to the public who can hear and listen to those discussions going on. I've seen that in the past, so I don't know if that's a good suggestion, but it's what I've seen in the past.
So originally, Frank and I were going to try to do pre-work so that the whole board wouldn't have to sit through hours and hours of discussion. And so what you're saying is I can arrange with Roxana that Frank and I agree on a time and a date. We want to have this, and then you can conference us in, and then that constitutes the, quote, broadcast to the public. And as long as we're on the state system, then we can do whatever we want to do in terms of conversation.
Yes,
Is that right?
yes, we would, and we would just agenda it either as through a normal committee or a special committee that would be been created.
Okay.
And yes, we can do that. So
Okay. So do we have to have a special committee to do this? Or do we have to have a special committee? Or
no, you can do it through a normal committee, but you would do it through a normal. Let me pause and think about it because I just made a recommendation without thinking about it before I walked in the room. So I don't want to give everybody all bad advice and then 20 minutes from now go
Take your
wait a
time.
minute. So sorry. Your normal if you did it through your normal committee would have a way of having its own quorum to make recommendations or whatever. If you didn't meet your quorum, then basically you would just have a non-approved recommendation from those two members to the full board. So it just wouldn't be an official, approve. How committees say this is what we voted on and we're going to do. But yes, you could do it through the regular committee. Yes.
and you just have two people decided to have a phone conversation about the definition of engineers and architects. Do you have to do it in the context of a committee umbrella?
You would have to because you all have adopted Robert's Rules of Order.
Okay.
And that's what that's what means your business would be through a committee. And it'd be real easy. Our agenda, Roxanne, we've done this on other programs where we have agenda and it would say whatever committee the item is, discussion of the definition.
So do we have to have three people on a committee in order to have a quorum established with two, or can two people be a committee?
They could. I do think you'll have to kind of give this committee a name. It's in my opinion, a new committee because you're not even in the same profession,
Right.
so you've
Right.
never really been on a committee together, and it can be the
Yeah.
educational committee or definition committee.
Yeah.
You'd both have to be present.
Right. But do we have to have three, or
I
can we
don't-
just
I
do
don't
with two?
think so, as long as you're both.
So as chairman, I'm going to appoint two people to the definition committee. I think that's my jurisdiction to do that. I'm going to appoint Frank Wagster and Kathy Ware. And I would ask that they get together and get with Roxana to notice their meetings through the state system so that anybody can listen to what that is, and then you'll have a dial-in number that you can have those discussions over the phone or some other electronic, whatever the necessary thing is. And like I said, then I think we could notice that on the state website like we do other meetings, and we'll call that the definition committee once you all decide kind of what fits into your schedule. We have to have a 7-day, 14-day, what's the notice?
Less than that, it's 72 hours, I think. So
Okay.
as long as I've got the agenda from you all or date that you can let me know, and I can be that middle person to set the date, give me some options.
Those conversations can then also be recorded and archived in case there's questions from somebody looking at the
Absolutely.
public record or whatever, and that way
Are you going to appoint a chair of that committee?
yeah, Kathy. She's got more time than you do.
I'm assuming she'll prepare an agenda.
Yes, and it will be to give it, here's the agenda, item number 1, and it's the only agenda item you have. Come up with a definition. That's not hard. Right?
I wouldn't think so. But
Well,
I'm just-
okay.
I want to make sure we're doing things right.
That's just my deal. Okay. Kathy, you're the chairman. Don't let it go to your head. Okay, Ricky.
And in case, just for you to consider, if your meetings coincided with these meetings, where you had a committee meeting either after the engineer meeting or like before this meeting, I would imagine some of the other board members could sit in like we do on our fall meetings and listen in and help, with that if you want that. So
Yes, and in my opinion, that would be the way to do it.
Are you suggesting they have good opinions?
They can listen.
They can listen.
Well, you have the audio visual all set up in these rooms anyway. Where
Yeah, it's like, we may have a 8:00 meeting before this meeting, or, that would simplify all the trying to get a telephone, teleconference going. And
Well, the only thing that and again, it's your committee, but I think having at least one meeting just with you two telephonically to kind of narrow down what you're looking at as far as some of the main items of the definitions and some of the key components of the definition probably would make whatever other meeting that you had that would be available to the rest of us maybe a little bit more productive, so that we're not starting from zero, we're starting from some area. But again, that's up to you all, unless Alton tells me it's not.
I just wanted to point out something Steve and I were just talking about. You know, we've got a third licensed entity that sits on this board, the landscape architects. Do you have a definition of the practice of landscape architecture?
We do not. CLARB has a definition of landscape architecture, and many states around us obviously have definitions.
Should there be an addition to a third entity to that committee that you just appointed, Mr. Chairman?
Yeah, I mean, that's the more the merrier. Yeah, Blair, you're on there too now.
All right.
Listen, you over here, by the way.
What do I do if I want to send somebody what I think it should be? Do I have to call the state and set up a meeting, or can I send it to, who can I send it to?
Yeah, you can send it to me like you would anything
So I can't
else.
communicate directly with any of the board
No,
members?
that is correct. You'll send it to
Okay.
me, and I'm happy to forward it and go from there.
Thank
And you
you.
all meet again in February, so to Robert's point, I think if you did meet one time, we can fit it in anywhere if it works for you all. It's not a big deal to do the phone conference calling if you decide to go that route.
That up as bad as it can be. That's good, but at least we're started, right? That's how you get going somewhere. You got to start. So, thank you all for being willing to be roped into this. CIDQ annual report. Are we at that? Right?
And it's on your iPads on page 114. Susan, I'll turn it over to you. I just wanted to put it out there for everyone to see.
This was their annual report, so this kind of gives a synopsis of the organization and the president's message. And so I was going to summarize it, though, make it much quicker. One of the important things that was brought up was redefining the definition of interior design. Our current laws and rules have a definition of interior design for Tennessee. This is an updated version. They're going to wordsmith it a little bit more, and then I'm hoping before I rotate off the board that we can bring that in and get that presented on rulemaking. So they based it on elements of purpose, qualifications, knowledge, skills, and task. And there were 8 people on the task force, 2 from Canada and 6 from various parts of the United States. And I think we had 6,676 exam takers in 2018 at the time of this report. So that's a significant number. We have 1,000 new certificate holders from last year. So we have 65,000 currently employed interior designers in the United States. 32,000 of those are certificate holders. So we have a long way to go to get everybody else taking the examination. We had the exam offered in 79 countries around the world, and now we have a French-speaking exam available in all sections for our Canadian and European friends. And they are requiring now that there are 60 hours of ID classes before you can take the examination. And it's a new requirement, so that ups the number of hours for classes. The new database that they were just talking about earlier has added a division for work history. So basically, an interior designer can upload their education, their work history, and it is this database is available to member boards only, which I'm glad you all have had that opportunity to take that training course. So, a couple things that I learned from some of the other jurisdictions are they have student intern members to the board. So the engineering students, the architecture students, landscape and interior designers, all could be an intern member of the board, and that's one way that they keep them in the fold. And whereas we have our grant program, this is another method that people use, which I thought was really a good thing. one of the other things that they brought up, and we had 4 really good speakers. One of them was from the Federal Trade Commission. She's chief of staff, and she went over the North Carolina scenario. And basically, the FTC doesn't care about having a board and having regulatory agencies. So that's something that we need to be aware of. So an average in certification certificate holder makes an average of $10,000 more per year. So that's something that the students need to understand. And that kind of goes across the board with everybody, you know, and you're all obviously have a greater monetary rewards. The other thing that I brought back was that now that we have access to, you know, the database, we can actually send all the certificate holders who are not registered in the state of Tennessee an invitation to be registered because we have access to their information. We have over 700 in Tennessee, and right now we have 395 that are active. That's half, and we need to get those other half registered. So I'd like for us to look at sending a letter to those or an email, whatever's easiest for you all, inviting them to participate in registration, which I think would be good. Any questions? So I have 18 months left on the board, just to let y'all know. So, not done while I'm still here, so, anyway. Okay.
But Ricky's got something, so I'm not done.
Very quick report. I was on a panel that went to Christian Brothers University in Memphis to talk about taking the FE test, and had a room full of students because they kind of bribed them with barbecue and that sort of thing. But it was great, and I was on a panel with 3 other registered engineers, and one of which is this electrical engineer who with IBM, who is who's their director of artificial intelligence, among other things. And this guy was an amazing speaker, and he's a guy from the industrial exemption world, and he's extremely passionate about engineers being registered, and had all kinds of flooded inboxes with all kinds of reasons and rationale why engineers who graduate with a degree need to go ahead and get registered. And it was really eye-opening. But one of the topics he brought up, just for us to have on our radar, is the whole area of software engineering. You know, we tend to think of that as, you know, buildings can hurt people and roadways can hurt people, but software is just whether your video games work right or your Windows interaction is good enough. Well, now we're going to have self-driving cars. It kind of maybe touches us in a little different way, that software engineering and the like is going to have a big impact on health, safety, welfare, and it already does. We know that, but this is in a new way. And so he brought up the fact that there are differences between programmers and engineers in the software world. And anyway, I just raise all this so that it's on our radar, this whole idea of software engineering, and this is going to probably grow in terms of affecting health, safety, welfare for us to deal with.
Right. Oh, Kathy.
I was just wondering what the deadline is for the next exam cycle so that we could anticipate.
So they're coming. We yesterday got the exam results. We are doing the merge of the information from NCWS 80 something past. So those exam results are going to go out, I believe. So I'll have it for you all from Wanda, because we updated it at the last meeting, and I don't have that in front of me. But you're going to get the inundation pretty soon. Is that what you're talking about? No?
The April exam,
passed.
what's the,
Right.
when are they due? They have to be done
March?
by
I thought we did
March
that
or
last month
something,
as well,
right?
in October.
If you look back in the minutes of the October meeting,
We presented
there's
it.
a item there that gives you what you're,
I'll look for it as
but
well.
it's in the October minutes.
Right. Yes, we presented in October. I'll pull it as well. But yesterday, we got the results. We did authorize NCWS to post those dates, but the next deadline is coming up. Wanda or I will find it and give you the page as soon as we can.
All right. Let's see. I have.
Can I interrupt you?
Go
Go
right
ahead and
ahead.
read them. Okay, so it
Go
is
ahead.
on page 10 of your iPad on the minutes last month. April 5th and 6th are the next round for the PE exams and then for 2019, and then October 25th and 26th of 2019. And a single day for the computer base is October 19th. Hopefully that page gives you those deadlines that you needed, Kathy. Does that look right?
It says application deadline is December the 1st.
Yes.
And January 1st for supporting documentation. So that means that we should be receiving an influx of
It is here.
applications now.
Yes.
Okay,
Yes.
that was
Yes.
really my
Yes,
question.
yes, yes.
I just want to know
Yes.
when to be deluged.
Yes, and a quick update on the system that we use for reviewing applications. It looks like we are almost there for a big change to not use that WinSep system that you all use, to move to something else. We've started testing it today through a WebEx. So as soon as that's done, at least definitely with the influx of the engineers, you'll get an email from us. It's a link, we'll get it on your computer. It's not as complicated as this other one. So I'm excited and hopeful that it'll help with this influx. Thank you.
Yes, ma'am.
A lot of the fact that Wanda needs some help getting all this stuff done so we can go to lunch. If everybody will take their iPad and reports and their name badges to Wanda and let her collect them over here, that would be very nice.
All right. Meeting is adjourned, and after that, I need
Have a motion?
Alton to tell us what the plan is.
We're convening at the Germantown Cafe. We've got a private room. I think everybody should have a menu. They'll take your order when you get there, but I gave that to you in advance so you know what the chef's recommendations were. That's what we're ordering from today.
Robert, did we have a motion to adjourn?
I thought I did. I meant.
So move. Second.
I think I just sensed that we needed to adjourn. I went ahead and called the chairman.
That was an executive decision.
Frank and Susan.
I think the chairman can adjourn without a vote. I think he can say, I sense
A motion to adjourn takes precedence over all other motions.
Yeah, but I think the chairman has that ability to adjourn a meeting without having a motion.
I don't think so, but we can check Robert's rules.
Let's
and
check.
verify that.
Under today's political things, he can do whatever he wants to.
We're on the record, Carter.
All right, well, let's get underway. Thanks, everyone, for coming to, what is this, our fourth of these QBS working group meetings. Appreciate everyone being here as we continue our discussion. Remind that our goal was to come up with a document that could be posted both from Competition Insurance and with other state agencies to be available that would be both internal and external facing, that would be helpful for as many people as possible to give guidance on this important topic. So what we initially did was just kind of have some discussions about QBS itself. Sharon was kind enough to share the document that she created for MTAS. And then we took that, and various members in our last meeting talked through the document about what to add, what to subtract. And my office reviewed the meeting minutes in order to take everyone's comments into a redline document, which has been posted online for quite some time. So hopefully everyone got to see that, and I know that Dustin also emailed that to everyone, and it's still available online in case for anyone in the audience wanted to find it as well. So I thought that maybe what we could do today is go back to that. I think that we got a few emails from some folks who had additional comments after our redline version to see what we wanted to further amend. I would love it if we were close enough that we could come to an agreement and we could go ahead and take that final step of of us getting the blessing of this group so that we could post this online and give that guidance that we were trying to do to everyone. So with that said, Robert, I know that you had some comments that I think that you might have sent to Dustin earlier.
Now, I think this just, I don't know if I sent them or not, maybe I did, but these are just a couple quick comments. First of all, and I know Terry wrote down design professional, but it's a guide for procuring, I think it's professional design services. I think that needs to be stated the other way. That's not a huge deal. I think part of the document obviously needs to give Sharon credit. But it's not your document now, So I mean, I think that I think giving her credit is certainly something that I think we ought to do. But it's now some other, and I don't know what we name that, but it's definitely qualification-based selection guidance for procuring professional design services in Tennessee. And again, I think we definitely need to give Sharon credit and MTAS credit for, based on the original document by MTAS, whatever, Sharon Rollins, however you want to put that. I'm not good at that part of it, but I think that's something because we've changed it a lot. And the next thing on my list would be, I didn't see anywhere, maybe we also ought to clarify who design professionals are, professional design services, what groups that applies to. There's some confusion on what, we know it's architects, engineers, landscape architects, I think, are in there. But then if you look at the Brooks Act actually puts in photogrammetry and some of the surveying services. So I wish we would add some language about what group are we talking about? We do say cities, states, and counties, but we don't. When we say professional design services, we don't say that applies to. And maybe just a sentence.
And so, Robert, I apologize that I don't know this off the top of my head, but in the Tennessee law that it incorporates the Brooks, do we not specify in TCA who's in and who's out?
I don't know that maybe it does. If somebody knows that better than I do,
yeah.
But the Brooks Act was amended to include land surveyors and landscape architects in 1988.
Tony's here. I don't know, Tony, if you want to introduce yourself and take a shot at answering
Tony
that.
Glandorf, Chief Counsel at the Regulatory Boards Division. The Brooks Act is a federal law similar to our law on QBS, but it's for federal funded projects, whereas Tennessee law is talking specifically about state funded projects. They are independent of themselves. I don't think I don't see that the Tennessee's, we'll just call it QBS law, contemplates the Brooks Act, but they're separate. But it's my understanding that yes, Brooks Act does specifically include other types of professions like land surveyors is in there, whereas our QBS does not have land surveyors in there. And I remember pulling back from my memory that I believe that we've had the conversation before, and there was an agreement that it does not include land surveyors, that their services.
And it looks, Robert, I see on page 4 where we've got TCA 622107 where it says registered architect, engineer, or landscape architect. And where's that page? Yeah, page 4 of the document there.
And that's fine. Maybe we need to take out where it says the Brooks Act was first, because it does mention that, and I just think that's a source of confusion because people would look at that and go, well, it's based on the Brooks Act. Why are they not? Just a comment. I mean, I may be wrong, but it
Where
does
is
say
the reference to the Brooks Act?
on page 4. The Brooks Act was further amended to include land surveyors and landscape architects. Simply put, federal law mandates that all architectural, landscape surveying, and again, I think professional design services required for federally funded projects. Either strike that out of there or something, because you've got two lists of people in here that could be confusing. If it says we're along the Brooks Act, then why are they not in both sets of things? And
So
that's
all you
my
want to
comment.
see is that the Brooks Act was further amended. That sentence, you'd like to see that stricken. Okay.
I just think that's confusing to somebody reading it to say, oh, well, it's land surveying now too. And I agree, Tony's right. They don't have surveying in the Tennessee Code annotated, but
So what you really want to eliminate is the line that says the Brooks Act and also the paragraph that says simply put, right?
Yes, that's exactly right.
also has a couple of paragraphs ahead of that you may want to strike as well.
Okay, so we can clean that up and send this back out for our final consideration. And I should note, and thanks to Tony, that he caught what appeared, we might have had a bad reference in there I've got to the top of page 5 of the document, a reference to Tennessee Code and said 12.4.107. I think it might have said B4, right, Tony? And Tony caught it and changed it to A4.
It should be A4, yes.
I have a couple of minor changes on page 3. I just don't want to get to, I only have a couple things. In that first paragraph, I'd like to strike the word state.
Sentence that begins with the purpose.
Huh?
That one.
To help Tennessee state, just strike the word state.
Yeah, but why I'm asking why.
What do you want to do?
Because this process is not what we use for state to be compliant with qualification-based selections. We use the process that's been put in place by the State Building Commission, and I wouldn't want to be confusing.
Yep. Step on up. Just introduce yourself.
Casey Anderson, American Council of Engineering Companies of Tennessee and Tennessee Society of Professional Engineers. I agree with you fully on the State Building Commission process. But this week I have been working with CPO on an RF, currently an RFP/Q, that will be following this. You know, it's a state process, but it's not one that we don't think. Chloe and I are working on that, but there are a few things that the state does outside of the building commission that do relate. Am I right
And
about
maybe we should just clarify state procurement, central
Yes.
procurement.
Does that make?
Yeah.
Is that okay? Because I do think that that's a place of for the very few projects that do go through them. I think that's important.
But you'd be comfortable if after state you inserted procurement? Is that what you said?
I think we should. How would we define?
I liked when you said central procurement.
Yeah, straight state central procurement.
And add another sentence to say other state agencies have a QBS.
No, the central procurement should cover all the agencies.
Your state agency have your own QBS procurement.
No. So what this means is that for the state, those projects that go through the building commission have their own procurement. What Casey was alluding to is sometimes, most of the time, the state selects architects and engineers through a project and through a state building commission project, and we have a process that's in a conformance, and so we don't want to get these two confused in the interest of making that clear. But sometimes the state procures standalone engineering or services, professional services that aren't associated with a specific building project, and in that case they go through the central procurement office. So I think we're just talking about there's two ways you can procure these services, is one through central procurement and one through the state building commission, and by defining this as the central procurement, I think we cover all the agencies because they would all go through a central procurement.
You have something else on page 3, another edit?
I think one of the things that's come into play is the word governmental entity and governmental entities is used, and I think one of the questions we have is that, you know, it's kind of a universal using, and I just wondered if that's the best word, whether sometimes it should say owner or is our question, but I think I just want to bring that up and see what the rest of the group feels.
Was there a word that you would feel comfortable with?
I think when we were looking through it, the governmental entity in that first paragraph, I think we thought would be owner. And then governmental entity in the second paragraph, we thought it could just stay the municipalities. But
And along the same lines of what Ann's talking about, it seems like the confusion that I've run into is with somebody down the line, for example, a school board, not thinking that they're part of this. And the way, when you read government and state and county, and it sounds like the county commission and the state offices and the local city government are the ones for this. And I know a school board, at least in the area I'm in, those are elected school board members, but somehow it doesn't trickle down that far. And there's a lot of people that actually put out RFPs and RFQs, not knowing the difference. And they put them out asking for fees, but they're generally not the county commission or the local city officials. It's somebody under them, or and so if there's a way, I'm not suggesting I know a way to clarify that, but I think if there is a way that would avoid a lot of confusion.
yeah, and I think that's why for the first two we would just say owner, so that because that says whoever is the owner or representing the owner seems more straightforward, and then the next paragraph, whether municipalities or even whether you need what comes really the question. If you just say all owners.
It is more expansive if you just take out what's in between the two dashes. And so if that's giving a broader but also clearer view from your perspective, I think that's a pretty reasonable request.
Yeah, that's what we would say. And then there's only one other place where they talk about kind of a governmental entity, and that's on page 6 that we saw. And it's step 2, form the selection committee. And in that case, the government, I would change to the procurement official. Just, I think, to Frank's point, in terms of making sure people understand that this means them.
So that would be the procurement official forming the committee should make a determination, that sentence.
Right. Well, it's just, the procurement official should determine based on the project size, the committee size, yeah. I think that was all our edits. We just were catching those few words.
I've updated on this, so hopefully we'll get them in real time during this meeting.
One thing I'd like to bring up, or at least question, and I think that has to do with the 12-1047, where it refers to several times the people that are being sent an RFQ for are firm or firms. And I've had this question asked to me, is that indicating that you don't have to go through a process of interviewing or getting qualifications from multiple firms? Can you just pick the firm you like and go negotiate a fee and go on with the project? Because the way it's written, it sounds like you can.
So Frank, are you wanting to see every time it says firm? Are you asking that it instead read as firms?
That's the intent.
And can you, to help us all look at the same example, could you tell us what page and paragraph you're looking at?
I think I found this in LexisNexis, but it's 12-4-107A1.
Where did you see it in the document?
Referring to what's referring to the document.
Oh, so you're talking about TCA itself?
If you're looking at, well, let me go back. Read the page 3 where it says legal requirements for contracting for a design professional. First thing it says there's Tennessee Code annotated 12-4-107, establishes requirements for procuring. And if you go there, and that's where I went, and that's what it says.
So you're thinking that that language should be clarified?
Unless the intent is to be able just to go to a firm and make a selection.
Yeah,
Now, a lot of times, local governments or whatever state has other requirements that make you or require you to get at least a certain minimum of proposals.
So I
But
think it would
this-
probably be easier for us to just not touch anything TCA related itself and just stick to the confines of this working document, because I think we could be going down, a difficult road if we were touching that.
The only
is
reason I
my
was
opinion.
bringing it up, it kind of, if you read it the way it's being read to me, you can surpass all of this.
You still have to make that firm selection, I would say, based on a qualifications, based on selection. So I.
Where this.
Is it just allowing for if there was only one response?
I think it allows for an organization to feel like, because of the unique nature of what they're doing, that there's only one qualified firm. And so they just work directly with who they consider to be the only qualified firm.
This instance was brought up to me as a school that had a firm design, not me, had a firm design a new school, say 4 years ago, and they want to do an addition. They're happy with the firm that did it, and they have no, that project is done and gone and settled. But they would really like to hire that person since they're familiar with it, and probably if they went through a process, they'd still hire the same firm, if you know what I mean. So they were going, the way we read this, we can just go, in our opinion, they're the qualified firm, and we'll hire them.
And I think that's one of the things we discussed in one of our earlier meetings, and that there are some local governmental agencies that do that in terms of how they determine the qualifications. And if I recall correctly, I think there was a determination that we weren't going to kind of
Follow that road.
we weren't going to police that.
Right.
I think would be the right way to say it.
Spirit of the law.
Oh, no, but I'm just saying it's written where it might be interpreted.
I think the remainder of our document would speak to that. This document that we have that goes through the steps that hopefully would address some of those concerns that were raised to you in the past.
Well, and if you look on page 4, I'll get my glasses, that may be page 3. On page 3 of that same paragraph, the bottom paragraph, the last sentence says, identifying and selecting the firm or individual best qualified to meet the. Now, that could be a one-man show. I don't know exactly what that means, but when it says individual, it means one person or group.
Sharon?
And I think that would be accurate, because this is really not necessarily always talking about project design services. So there could be times when they're just seeking a specific consultant's particular expertise, and it could just be one proprietor or something.
Sharon, I was just going to turn to you, since I think this is part of the document that you had originally authored, to see if that was within your understanding, what Ann just shared as well. Okay, great.
Oftentimes in practice, we see that when
I think we had some discussion of that expansion of the scope of services in either the last meeting or the previous as well.
Sharon, I'm sorry. Can I get you to speak in the mic? They're not going to be able to.
I'm sorry.
Thank you so much.
And the way mine print. Right under procuring professional services and the process. I'm looking at the edited, yeah, your edits, yes. Talking about the same thing, Ann? Okay.
Yeah, it looked like the paragraph that Frank was referring to was the, just talking in general about that should be a consideration over cost, as far as, getting the best qualified firm. And it's just merely stating that they're using the term firm and individual as indicating the winner, the person who got the award. And so I think the wording's fine.
I do have a comment on that one. The one you just brought up, Ann, about the, Sharon, excuse me, about the, I just put a sentence that says, good guidance is to make sure that, and that's under where you have the expansion of scope of services. I think good guidance is to make sure that the firm provides proof they have experience in the expanded scope, and maybe just that sentence, so that the municipality has something on record to say we gave this expanded scope to this firm, and they showed us 3 projects that they had done that were similar, because the expanded scope may be on the same project limit, but it could be a different sub portion of that. To me, it's good guidance to do that.
I think so. I think we just have to be sure it's in a separate paragraph apart
Yes,
from
ma'am. That's what I'm saying too. It's just, and it can be a one sentence that says good guidance is to make sure that the firm provides proof they have experience in the expanded scope. And, that can be a page of, we've done this 4 projects in the same whatever. I mean, it doesn't have to be a big deal.
Did anyone else have edits just while I take down Robert's sentence?
Got it.
I'm sorry.
Doesn't need to be in the sentence. I mean, in the
Added that. Unless there were objections to Robert's inclusion of it, I didn't see people getting out pitchforks. So. Okay.
Wouldn't be the first time.
All right.
I've got the minorest thing on page 6. You're going through this laundry list for defining the project, and you've got a lot of questions. There's the what, and the when, and the where, and all of them have a bunch of questions underneath for people to consider. I guess I got thrown off by the edits under who, because they seem to be statements of what needs to be done or how it should be done. It's like in the wrong place, because it's going through the thought process and thinking through what you want to do, etc. And then it has these firm statements of, but you need to do these things this way. And I get that somebody wanted to add those in. I just think it's in the wrong place.
Is there a different place you thought it more appropriate?
I didn't look that
Okay,
far, but I'd be
sure.
glad to do that for you and make a suggestion.
It seems like it might be appropriate in step 2, form the selection committee, maybe between the first and second paragraph, just defining, committee members should be knowledgeable and proposals shall include. So.
That sound good? I can't remember who added that sentence, but no objections. Okay.
Actually, the second sentence, proposals shall include the names. So committee members, that section should go, I think, in step 2 in after the first paragraph, but the proposal shall include, that should probably go in step 4, evaluate statements of qualifications, because it's talking about the proposals you're evaluating, would probably be the better fit.
Where in step 4? Just because I'm doing this right now live. Did you want that above the paragraph that begins with after evaluating.
Actually, it might belong in step 3, where it lists what should be in the,
Where it says the package should contain the following information.
I was thinking the paragraph above it, since it says proposals shall include names and qualifications of the team to be used on the project, that would seem to be the design professional team, which would fit under, I think it might need to be modified, but I think that's.
No, so this is how do you seek the best firms? That's the section you're looking at. And then the second one is the RFQ package.
Okay.
Would it work under the RFQ package should contain the following information, and then rather than restate as proposal shall include, but because we're talking about what's in the package itself, right? That it has to have names, qualifications, and substitution must be approved.
You might be onto something. A2 is the sample document,
Okay.
which asks these questions.
And if I were to put it anywhere, I would put it in on the very top of page 9, right after the second bullet under RFQ packages as part of the second bullet, because it says the requirements for the statements of qualifications shall include the names and qualifications of the team to be used on the project, and substitutions must be approved in advance. That's where I'd put it.
And because as I'm editing, it's kind of throwing off my document. What was the paragraph?
So it was step 3.
Okay.
There's 2 sets of bullet points, not the first set of bullet points, but the second set of bullet points after
Okay.
the RFQ package.
Uh-huh.
Bullet number 2 just
Got it.
is added to the end of that statement in bullet number 2, I think would be the right place to put it.
Perfect. Got it. Else? And maybe while we're thinking about it, Robert, to your initial point about making sure that we were crediting Sharon, but noting that this was a separate document, would it be acceptable to the working group if we noted that this was a document created by this working group for the purpose of providing guidance?
Yeah.
And curious whether you would want to be listed in your names and the professional capacities why you're here as well. I don't know for the people who are representing a state entity whether they would want to be noted as well.
I would think
Maybe
we
something
could
to
put
think about.
members of the state architect, architects and engineers, whatever the groups that were represented. I think that would be appropriate because, names may change in different departments and divisions. So I think
That's a good
maybe
point.
just who was involved in the conversation or who was involved, what departments, organizations were involved in the.
And I think maybe we could say based on the and I think there was based on the MTAS guide, potentially giving Sharon as developed by Sharon.
Yeah.
And modified
from, or,
by
yeah.
this committee that included representatives from the Architecture and Engineering Board, State Comptroller's Office, State Architect's Office, MTAS.
I think that's perfect.
Great. And Casey?
I was just going to say, but a couple of different things that studies and things like that have been done. On occasion, people have to go back 5 years, 6 years later for intent or for specifics on something. So on occasion, it can be helpful to have specific names written down, even though like Robert, say you're not still sitting there or whatever, to know that it was Robert Campbell, not generic AE board. Do you know what I mean? Like, in case there is a question down the road.
In that regard, would it be sufficient that we've established a record through recording these?
I'm sure it would. Never mind. I'm just going to be quiet now.
Well, I'm not objecting to it, personally.
What if you added an appendix? Members.
So what you're saying is the industry would like to have the names of the working group members?
Yes, that would be yes, ma'am.
Well, we're not exactly in hiding, sitting up here being
Right.
recorded.
No, just maybe even an
yeah.
appendix. I mean, just
Sure.
kind of added a list.
Okay. We'll come up with something.
In that vein, should we include that it was also developed with consultation from the industry groups?
Right.
With input from relevant industries, licensed registrants. Have we had any random citizens speak to the QBS group? Your title will reflect that. I'll try and come up with something that covers what you're looking for as we send it back out.
And it might be beneficial, sometimes there's just a dedication paragraph or, background paragraph that, how this came about.
Oh, absolutely.
So that might be the place to put that kind of information. I just don't know.
That's a great idea.
I've got, and this is just I don't know if this is a statement to be added yet, but maybe a quick discussion. In step 4, evaluate statements of qualification. It's on mine, page 9. I've got and I'll tell you why I've got a little bit of concern about part of this. It says, after evaluating the written submittals, the selection committee chairman should compile all score sheets from individual committee members. So that sounds good and well and clean, and the process sounds very, very nice. But if you have, say, a 3-person committee and you have one person whose scores are obviously biased, out of whack, whatever, that can really torpedo the whole thing. And just, to me, there needs to be maybe a follow-up with the group where they present their score sheets, or that option, so that everybody can go over and say, well, why did you put this person as the lowest when everybody else in the group had them the highest? Or I just think there may be something they didn't understand during the process, or because you weren't able to get somebody that technically understood the whole thing, they were more swayed by some other factor. And I think it's good for the committee to get back together with their score sheets and kind of go over that, and just to check to make sure that everybody has a score that they can stand behind. And again, I've heard about this in different selection committees where somebody will, and you'll look at it when you review post-selection, and you'll look and somebody will have one firm, everybody will have them up their top firm, and then one person will just have them at the very bottom, and you go, well, they couldn't have been that bad to be the last firm. You know what I mean? And you suspect why that happened in some cases, but you don't know. So I don't know how to put that in there, but just a simple fact of compiling the score sheets to me doesn't seem like that's enough. Maybe they need to get together and say, okay, you had them as 1. Okay, you had them as 2. Why'd you have them as 6?
So, Robert, what I just wrote while you were talking, and this would be after the sentence that begins with "after evaluating."
Yeah.
I just inserted, the chairman may wish to reconvene the committee to discuss submitted scores.
I think that's fine.
Is that all you're looking for?
I think that's, but does that make sense? I mean,
Yeah.
to me, we've just seen that from time to time, especially with different groups, that you just have one that gets torpedoed for whatever reason. So, okay. Thank you.
I also like the fact that they kind of keep it loose in terms of compile, because sometimes people compile the scores by averaging all the scores. Sometimes they take the median, and so I think it just depends on whatever they do to compile them should be fine. So I like the openness of that.
At 10, you may take the top, I mean, I've seen them take the top and bottom out or whatever, and that gets rid of some of the bias. But if you've got 3, that sometimes doesn't. So you're exactly right. Good. I think that's
Well, following that a little further, whoever wrote the score, the items that you're scoring, can write a very biased scoring set.
It's true.
Experienced that before. So there's another way to buck the system, I guess you'd say.
Not going to solve all the problems.
Anything else, or looking into the audience for random citizens? No comments.
On page 9, step 5, you're talking about, I guess this is kind of a decision point in deciding whether you're going to have additional interviews, site visits, etc. And I guess it says notify firms of results. I just don't know that the title necessarily, it's going straight to notification. It makes it sound like it's the end of the process. So I wonder if it ought to, incorporate something about selecting a short list for interview, or, that seems to be what this section's talking about. In some cases, if you aren't doing the interviews, I suppose you do go straight to notifying the firms of results. And for the ones that aren't shortlisted, I just felt a little bit of a disconnect on that step 5 between the titling and what's actually beneath it. So I guess you're going to ask me what I suggest, aren't you?
That was the
You just put evaluation in front of results.
Yeah. I think that would be good.
evaluation of results and conduct site visits.
Notify firms of evaluation results, not evaluation of, just evaluation results. No, okay.
On page 13, and you probably talked about this, I wasn't at the last meeting, one of our representatives were, they're talking about the ways of computing fees, and that's pulled out altogether. And I know people do it different ways, there's different fee formulas. I mean, should there be any discussion about the different approaches one could use, or you just want to
Isn't
keep
that
it
into the
open?
appendix now?
Oh, is it? Okay.
I thought that was moved to appendix.
Appendix A14.
Oh, okay. Well, never mind then.
Yeah, because I agree, it's helpful information, a lot of people don't know.
I think that the reason why we did this was that we were trying to get the document a little bit more digestible, so that someone could still get all the information if they wanted to flip to the appendix, but maybe they wouldn't drown just as they work through this.
Is that the same for the contract elements too?
I believe so.
Yeah, all right. Well, that covers it. And one other thing that I thought, just in reading through this document in general, and knowing that I have missed a couple meetings, when the group first got together, there was a lot of discussion about making sure that people were aware of their obligation not to judge it in a financial way. And I honestly didn't see a lot of stress on that in this particular document. It's good guidance, it's how to do it, but some warning type things about kind of stay away from doing this, and don't consider these type of costs, don't accept these type of
I'm smiling because I'm going to follow up with that in just a second.
I guess what I thought was the big drive that got this committee all together. I'm not sure that the spirit is here in the document, but if others are satisfied, then I'm satisfied as well.
So that's the question I had, and I talked to Carter before the meeting. We get the document done, it's ready to go, we post it, everybody's out there doing this, what then? What happens if a professional violates this document? We don't tell them what that, do we need to tell them that? What if a city, county, state, or the entities violate that document? Who's there to do that? I think we need to let them know there will be somebody that will be responsible, because if you got a law on the books, somebody ought to be responsible for policing that law. I mean,
Yeah, and just to be clear, I wasn't advocating for the policing of it per se.
well, but again, from the A&E board, it spells out engineers, architects, and landscape architects. Okay, the only people that I know that have any jurisdiction over that group of people are the Architects and Engineers Board. And we started all this because we felt that our registrants were violating the intent and of these type of documents, and we needed to make sure that they didn't violate a state law. We made, before somebody goes out and commits a crime, we'd like for them not to commit a crime. And it was trying to be preventative, which I would hope we would be preventative on the other side, where we don't release bad RFQs out there, so that the city, state, whatever entities are not violating it as well. And I agree with you when what you said is that we don't say in here anywhere, if you violate, if you're an architect, whatever, and you violate this or something, and I don't know how to put that, but there's no emphasis on that. It's just, okay, here's this, use it. If you want to, fine. If you
Well,
don't.
it does say it's the law. I mean, that's one of the, it's a standalone bullet point. It says it's the law as to why follow the QBS selection process. That's the very final bullet point. We also have in the why procure design professional services reference to TCA and the requirements there related to it. So, Robert, I understand what you're saying about that. You want to make sure that the registrants know to follow the law, and that the A&E board is the appropriate authority for enforcing that. That doesn't change. The A&E board is still the appropriate authority. When we convened about this document, this was to make sure that it was going to be great. It was going to be useful not just for registrants, but also for the public bodies. And this working group might have a different feel than me. It feels to me that we're almost there with this document, and that if we were trying to bring about putting in a new section of some information that is, in my opinion, superfluous, that we're going to get a little sidetracked here. But
Yeah, I wasn't meaning to sidetrack. I was kind of aiming more at some of those guidance type wording where you're saying, don't obtain this financial information. Don't, and maybe some of it's in here, or maybe I didn't do a good enough time reading it. But no, you had some comments.
Before we have random citizen talk about this, so I don't think it is in there, and I don't think it is superfluous to at least have that, because if we go through all this effort to develop a document, then what happens after that? If it's just a document, it's good guidance. So if I have a registrant that says, I've got a bad RFQ, do they just come straight to the A&E board? Do they go to the comptroller's office? Who do they go to get remedy for? And it is the law, but in every law there is a body somewhere that oversees that law. They're responsible for that section of the law. I mean, that's why we have laws. Different people are responsible for different sections of the law. So who's ultimately responsible? And it may be bifurcation of that. It may be 2 or 3 different people. I have something in here or some guidance that says, if you're city, state, or county, the comptroller is going to audit you and do whatever. If you're a registrant, then the AE board's going to, because that's the people that are spoken about on the other side of it. And I just don't think we make that clear enough in the document that there's some other thing that happens after this. That's my point, so I'll shut up.
I think Kathy's point is well taken. That is why we're here. That is what got us here, is the oversight of qualifications-based selection, and where that goes and how that goes, and the fact that the AE board, the opinion was that the AE board, if they only have authority over their registrants, the registrants aren't the ones who are in violation necessarily of the law. If they're the municipality who puts out an RFP versus an RFQ, whether you like that language or not, but the registrant, the municipality who's asked for cost or fee is the one in violation of the law. The registrant is in violation of the rule to follow the law. That's how we got here at the beginning of all of this.
And I think at some point down on, we didn't have a real clear answer to that, and it was decided that we really just need to provide really good guidance, which is what this is supposed to be. I guess I was just more for firming up the guidance, so you can say, wait, what'd you just do? Look at this guidance.
Right.
Is it?
There's all of a sudden there was not a document that was public record that was approved by anybody, to which those of us who randomly police that who are the voice for the registrants to say we're uncomfortable responding to this procurement you've put out because you're asking for cost inappropriately. Here's the law, and here's some information on why we think you're not doing it right. That went away, so we needed another piece to put in. So that is a really important piece of this, of why. I just want to remind you why we are
Maybe there's
here.
a way we can address that. If we look at why follow the QBS selection process, right? First of all, I would put it's the law as the first bullet point.
First, agreed.
Let me just start with that.
Start and finish with it.
I would
if you want.
start with that, and at the end, I think at the last bullet, I would add something that says to set up a framework for selections based on qualifications rather than lowest cost.
Well, in the
This is public money, and you want to have a well-designed building, not a building that's based on the lowest cost. So I think that's key when you're trying to educate our city and local officials that don't understand, that have never been involved in the procurement process, of why it's different than working with contractors. So I agree.
Yeah,
just
and
a little bit.
also under step 3 about soliciting statements of qualifications, perhaps there could be a bit more there as well. And you're going to ask me what? I'm not going to have the answer, but there could be a little bit more. It's just guidance, but a little bit more teeth to that particular.
My recollection of where we were is we identified we had two problems. One, we have the issues for the registrants, but two, we have the issues with the municipalities or the governmental entities issuing solicitation documents that aren't in compliance with the law. And I think we kind of determined it was harder for this body, this QBS group, to police the registrants, but we could issue some very strong guidance to the people who are kind of starting the problem, which is the folks issuing the solicitation. So I guess in my mind, this was very much aimed at those folks who were issuing the solicitation to try to train them of how to do it right. And I think, Robert, you're correct that there probably ought to be something in here about, if you aren't, that registrants who feel like it's not being followed should reach out to the procurement official. I mean, I think you would always want to reach out to the lowest level first to try to inform those who probably are doing this unintentionally and unknowingly. So I think the idea of emphasizing that this is about how to procure those design services in compliance with the law, and that it's not supposed to be fee-based, could be hit, maybe more directly, maybe more up at the front, as maybe why follow QBS should be the first paragraph, even before they know what it is. Just a thought, but I don't know about this document talking about how to police folks, because I think it was more intended as the educational tool and the hope that that those who saw an offensive procurement could hand it out and say, oh, you need to fix this and here's how.
And I think that's a great statement too, because you got to kind of where I'm trying to get to. We don't say in there, if you believe this guidance is not being followed, please reach out to your local procurement official to discuss why you think that's written incorrectly based on this guidance. If you believe a registrant or design professional has, please contact the AE board to discuss why. I mean, there has to be some mechanism for them to go to somewhere to start, because I agree, most of the time these, and I've got one right here that's asking for 2 sealed envelopes, but there needs to be a step for people reading this to go, I need to go talk to that person, I need to go talk to that person, and then that needs to get escalated. Hopefully it can get fixed right there. It's just a simple something.
Maybe even you add that issuing a procurement like this puts the respondents in jeopardy, puts their license in jeopardy. Maybe that's part of your why you follow QBS, and it reminds them that they could be endangering,
Why is everybody apparently against having any kind of consequences to the issuer of the RFP? What? I mean, there is consequence to the architects and engineers that take part in it. They come before the board and there are fines and et cetera. Whoever the governing body is that issues an RFP, there is no real consequence other than somebody calling and saying, hey, you're not supposed to have done that. But when you put a consequence on it, all of a sudden they wake up and take notice. But I've heard nobody express any desire to have any consequence for the issuer.
So, Frank, I would say that's not what we're doing. We are not setting the consequences here.
Oh, but
we're just making this guide.
Teeth out of it, I guess you'd say.
And I don't think it's fair to say that we're avoiding that or don't want it to happen. It's that it doesn't naturally fit under the rules of we haven't found the natural fit, I don't think, as far as where that consequence comes in. Now, for the registered firms, it's a little bit easier of a question, but
I think that the couple of consequences. One is that their procurement should get stopped. That their project will be delayed, right? If they're doing it wrong and they get caught. I mean, and then I would think part of it is the government officials who are violating the law are really not under our authority, and any consequences to them is really.
I'm not saying we should do it. I'm just saying that's the problem.
I thought that was an insightful observation, though. There are a couple things that I kind of heard, and I just don't want to lose sight of. First of all, I like the idea that the section procuring professional services in the process, or at least those 2 questions, and I would change that to why procure professional design services, so that we're consistent with what you had done on the front. That, and then why follow the QBS selection process, should be the very first thing in the document. That should be what people hit first, like, why are we doing this? And then maybe in terms of why follow the QBS selection process, in addition to saying that this will set up a framework for selections based on qualifications rather than lowest cost, maybe we should also ask a bullet point that says registrants that respond to RFP for professional design services are in violation of their license. Specifically say that if you, as a professional designer, if you respond to that, because I think that's, when we talked about this earlier, that's kind of the teeth. Like, if I'm a procurement official and nobody proposes on the work when I put it out on the street, right, then something's wrong with my proposal. And I'm going to start asking questions, why didn't I get any responses, or why wasn't there any interest in it? And so that might be the way to kind of put it out there and at least start that conversation about the fact that you're putting, you as a procurement official, by doing this, and a licensed registrant by responding to this, are kind of breaking the law and causing somebody else to break the law.
Let me say that when this was first developed, our clients are municipal governments. So it was written for the municipal official to seek design services. And we weren't aiming it at board registrants. So it was written for that purpose. Also, city officials have to follow proper purchasing laws, including purchasing design services. So MTS as well has a guidance on that, and there are consequences for not following purchasing laws properly. So I think that is already in the works, you know.
Take Robert's thing here as an example, which appears to be a RFP from a municipality. Who is that? That's from Memphis, Tennessee. I mean, what takes place if this is brought to whoever governs this? What actually happens? Say, you're going to have to throw this away and do it right, or what is the the process?
It would probably be an audit finding.
And after it all happened and the building's half built, or when is it audited?
Audits are after the fact.
Right.
I guess I see it similar to any other law that's out there. There isn't necessarily that here's the one person to report to in any particular case if this happens.
And I think, to add to what Kathy's saying is, I know, Robert, you were talking about there's always somebody who's responsible, and I would say I somewhat disagree in that if you look at every statute, there's not a police officer for every part of statute. Part of it is to set the professional standards, and then when people break those professional standards, to give other individuals recourses to hold them accountable for that in a variety of ways. And so I think that it's challenging to understand how you do that, and then what would be the penalty, right? Because what's the penalty for the crime? And there are a lot of things that go on. Is how do you, after the fact, and we deal with this fairly regularly. One came across today. What happens when somebody gets outside of the guardrails and goes ahead and does something? Then you just, at that point, you've got to kind of figure out, what's the risk that the state's at after the fact. So I don't think there's any way we're ever going to catch everything, but I think, setting the intention and starting to set a framework for good people to behave well is really what important.
I'm sorry, go ahead.
Oh, I was just going to say, do others agree that, with step 3, where it's talking about soliciting statements of qualifications, that there should be something a little bit more in there saying, when you do this type of process, make sure it doesn't include any fee-based items or any fee components to it whatsoever. Yeah.
So where would you insert that?
I'm not.
That's your.
Maybe
we'll put it in there.
Add a section the RFP should not include, but at the end of section 3. I mean, or you could even just add a bullet at the end of the section, which would say, make sure that all of your criteria is qualification-based criteria, not cost-based criteria.
Any items that you put in the RFQ that could potentially allow for cost to be considered should not be in there. I mean, and again, I've got one here that's called about 2 envelopes. Well, everybody goes, well, we're not going to open them. Crap. Come on now. You're going to open them at some point in time. And that's a mechanism to find out what your fee basis is, and that shouldn't be in there.
And I would say, though, that it's not the way we would choose to do it, that somebody who asks for that envelope, they are not in violation of the QBS statute. You would have to prove that they're looking at, all that cost information and weighting it, and not just the fact that they asked for it.
Random comment, number 82. I think the more plain you can make that language, cost is not a factor, period. Quick and not lots of flowy words about this, that, and the other. No cost, no fee, no whatever, so that when someone is, let's be honest, when I used to send out the QBS frequently asked questions, I often, you know this, Carter, I often highlighted, this is the one that I think, rather than reading all 32, why don't you just pay attention to number 12 that pertains to what this is. I think to be able to highlight something that says no cost would be really helpful for some.
Strengthen what you've written here. Ensure the criteria is qualification based and cost cannot be a consideration. Is that too strong?
Well, it is qualification based and not cost based.
Right. So that's what, and I tried to capture what you said. I wrote ensure that criteria is qualification based and not cost based.
But and Kathy, you said and
We kind of like that strong
and
cannot
cost is
word,
not a consideration.
You know, really.
We like that. We personally like that you cannot ask for cost.
Instead of ensure, make sure that
Cost may not be
that
requested.
all of your criteria is qualification
Costs nor
based.
fees may be. You may not request cost or fees or something. You know, it's hard. I think it can be strong language if that's what you're trying to say.
And cost is not considered.
Not even
Costs
considered.
cannot
though,
be considered.
Not asked for.
Asked for.
Oh. Cost cannot
the
be
RFQ
asked for or considered.
The
Right.
the
Right.
RFQ should not ask for cost information?
Yes. Chloe is always the wordsmith.
Yes.
Chloe, can you restate that?
RFQ should not request cost information? Or
To Ann's point, I think this needs to be the first thing you see in big letters. I mean, the rest is a guide to follow. This tells you what you're supposed to be doing.
Explains why you continue reading.
Right. Even if you don't read any of the rest, you should read this.
Would you all consider the primary audience that you're writing this for is the registrants?
The goal was that it would be for both registrants and public bodies.
I think the idea was that it's primarily written with the eye towards the public body for them to use as a guide, but it's written in such a way that the registrants can use it to provide feedback to those public bodies and say, this is why, if you look at this guide, this is what you're not doing, and this is why it's a problem for us.
To go back to the history, and I did want to draw a little distinction from what you said, Casey, that it was the removal of the FAQs that initially set off this process that brought us here today. That along the way, that the consideration, what you talked about, and to Robert's point about who has the authority to enforce this on the public bodies, was something that briefly came up during the legislative session, but the driving force was always about the FAQs and being able to provide guidance.
Our understanding was that we were told that the FAQs came down because they were providing guidance, because they were interpreting that the AE board was interpreting things, and therefore
Because the AE board, without the input of the other entities, was
it wasn't without
providing
the
guidance
because
onto
they
the
didn't have
others.
the authority to tell. My understanding, and I don't think any of the staff was here at the time, but lots of you all were. My understanding was that they thought that the AE board was trying to tell municipalities and other governmental agencies how to write an RFQ, and they didn't have the authority to do so, and therefore we're going to pull the frequently asked questions down on the page because they were being used to inform those entities how to write an RFQ correctly. Am I right about that, Chairman?
And what we have, I'm sorry, and what we have here is the solution, that we have the guidance that is both applicable for the registrants and for the public bodies.
Yes.
Right.
We've got guidance,
Yes.
and let me give you the end of this part of the end of the story. And this comes back to the comptroller. You are doing a good job on I know on like utilities. Okay, we have these meetings, and I do work with utilities, and they always come back from some training that I think you all do with them yearly, and they always go through so-and-so got in trouble for doing this, so-and-so got in trouble for doing that, so-and-so got money taken away for doing this, so-and-so got under federal indictment for doing whatever, okay? But they know there's a stick in the room, that they at least have to pay attention to this. And I think in order for this to be completely effective, that needs to be emphasized every year by not just MTAS, and I know you all do, but by the comptrollers, whoever does those kind of things, because they listen when you say, hey, you might go to jail, or you might have your funding removed, or whatever, and that makes people pay attention and take stuff more seriously. And again, I've seen it on the utility side where they used to say, oh, we can do whatever, and now they're coming back from those meetings going, you know, and it's really changed a lot of the discussions and the behavior within those boardrooms. It really has.
That's a good point, and I'm sure our local government folks would be happy to point to this guidance, especially as it's first coming out, and make sure people are aware of it.
That's where I come from, and that's been very effective in that.
I was just going to add that I also think that is part of why I think it might be important to list out who is on this committee, so that it's clear that the comptroller's office was here, the state architect's office was part of MTAS, CTAS. I think that piece is important rather than a group of, I think to make that clear is okay.
I think we always felt that the Comptroller's Office, the Architecture and Engineering Board, MTAS, CTAS, and the State Architect's Office should be named. The question was whether it should just say State Architect's Office or whether it needed to say Ann and Chloe. And to that point, is the State Architect's Office and the Comptroller's Office good enough, or are you expecting Ann and Chloe and Kathy listed?
We've never really voted on anything as a group. We are definitely not following Robert's rules, but maybe just kind of informally, do we want to be listed in our individual capacity, or just where it would say Commerce and Insurance, board members, etc.?
But either way.
Do you have a preference?
No, I mean, I think my initial thought was just to recognize the organizations that we're representing, and as opposed to the individuals, unless the industry or anybody, random public people decided that they felt like our names were appropriate. Because I'm like you were quick to say, Carter, I'm not trying to hide my personal involvement, and that's not a problem for me. I just thought maybe it gave it more gravitas to talk about the offices and the organizations as opposed to the individuals, but that's just my opinion.
Kathy Ware, I'm on the AE board. I'd just like to say that I think it would be much more powerful if you had the offices listed and the representatives within each office, your names. And I would say that because I actually was, in 1999, I'm dating myself, but I was actually part of when all of this started. And that's hard to believe, it's 20 years ago. But about 5 years after that, we had to go back and speak to the legislators who carried the legislation. And to actually know who they were, the people, was very helpful so that you could find a legislative intent, so that you could ask questions. And I feel that we would miss a great opportunity if we do not list your names, because 5 years from now it's going to be different people on the board. It's going to be different people in different offices. In February we're going to have a new administration. So all of the people are going to evolve over time, and I would encourage you just to think in terms of name the office, of course, but if you were willing to put your name to the document, and I think you all are, that could be really useful to the people who come after us, and that's just an opportunity that would be missed if we don't do that today.
Do we need to vote, or will head nods suffice?
You might just say, is anybody opposed?
Okay. Well noted. Is anyone opposed? Speak now or forever hold your peace. Okay, all right. So we will list with our agencies, our titles, and our names. Great.
We're including Casey, right? No, seriously,
Right.
we're including the organizations that reviewed this too. I'm feeling like she read it just as thoroughly as we did.
Is that accurate? Did you read this, Casey?
Casey and Ashley, would you be okay with you being named as well?
I'm more than happy to be listed. That's fine.
Okay.
All right, we'll do that.
Yeah. Being on this alone.
So there might be some other things that people haven't raised their voice on yet. And while you look for those, I think that we basically have what we wanted. And there have been a few edits that were made today, so we could, my office could once again send these back out to everyone. And I don't think that we need to have any sort of formal vote where we would need to call another meeting, but maybe by email. If you are good with the document, if you can note it, and we'll include all that in the email. Will that form work for everyone here?
It will for me, but I don't think I'm on Dustin's list.
Double checked it then.
Yeah, well, I think you're
That was clearly a joke, Robert. I apologize. Yeah, we'll make sure you get it.
Yeah, okay.
I would also love to be added to that list if my name's going to be on it. But I have a quick point of clarification. The things that are both crossed out and highlighted, what's the scoop there? Are they in or out?
To appendices.
I just wanted to make. Okay, we're just going back and forth on in the weeds over here. We didn't want to get in the weeds with you. We just want to make sure. Thank you.
There is actually a comment that goes with those in the edited document that says what appendix it moved to.
Got it when you look at the review, whatever that is on the side.
I have a quick question about, it sounds like we're going to wrap up pretty soon. So before we do, you all have worked so hard, and especially Sharon, on this. So I want to make sure that before you wrap up, if there's a next step process, how are we going to roll this out to the county officials and our design professionals so they're aware this is available? And if so, have a consistent message across the board. So, I don't know, Casey and I are writing random things, and state architects, just so where it's a consistent message to everyone. So
Sure, and I'll reiterate our promise that we're going to put this up on our website, and I think we had also said that we were going to work to get it hosted on other state websites. So we will definitely do that. It seems that maybe this could be something where, as we move along, where people would be able to, report, email back that, hey, I got this in front of such and such conference, or and then we could distribute that out because we have this email group, and because the goal definitely is to get as much visibility to this as we can. So if that's something, if we're going to have a continuing effort here, that maybe we could just agree that we're going to try and update as best we can about our efforts to promote this and get this out. Would that, Ashley, is that what you're looking for?
I don't know if it needs to be kind of some sort of intro or a paragraph just saying, on behalf of this group, we have prepared for you a guide, or just something so we can include it in our membership to our architects and to our engineers, like an executive summary kind of.
I was going to add a preamble to it.
Yeah, a preamble
that just touched on why this group was formed,
Right.
what the purpose was, and what we hoped the document would be used for.
Yeah, so then we can just use it across the board and say, here's where you can find the information obtained.
And as far as the county officials, municipal governments, I wonder if MTAS and CTAS could push it out in some way.
I think so. We can certainly put it on our website and perhaps offer some training on it as well. We an elected officials academy, that would be the best place to get the information.
One other question, this is kind of to Roxana, because sometimes I say things that give her more things to do than she needs. But since she does have a list of all the registered architects in state and out of state in Tennessee, just a short email saying this is our requirements for procurement.
Yeah, we have that electronic notification system that we could use too.
With a link, and link it to the information. It doesn't have to be some huge newsletter or anything, just you're registered in Tennessee and you need to be aware of this.
Yeah, we'd be
Yeah.
happy to send that notification.
I just really want to, Frank, just one word, Smith. That this guide has been created. It's it's not requirements. There are nuances that people can do that are equally as good. This is just a guide to give them a framework if they don't know where to start. It's not saying that if somebody nuances it that they're wrong.
Okay. Well, unless there's anything else, then I think we can wrap up our final QBS working group meeting. I'll follow up with the email, and then we'll have those final steps that we just talked about. But thanks so much to everyone who's been here. I really appreciate the work, not just at the meeting itself, but all of the homework that we had. And there are a lot of documents sent your direction, and it was a pleasure getting to work with all of you. So thanks so much.